Okay, good afternoon, everyone. So we'll start this webinar, which is the final event of a project that we were conducting during the last 2 years with the team of DCI-Belgium and many partners, a project called Child-Friendly Justice in Action. It will be introduced more precisely by Laurent Beauthier in a few minutes, but as the final event of this project, we would like to raise the attention and awareness on the topic of child-friendly justice as at large, and also showcase and present the realization and the outcomes of this project. I think that this event comes very timely in a way because the guidelines of the Council of Europe on child-friendly justice are just turning 10. So 10 years ago, this was a brand new model. I would even say a brand new idea because usually we had discussion concerning child-friendly justice in different fields, in penal justice, in civil justice, in administrative justice. And this is the first time where there was a try, and a very good try, to put together all these dimensions and to try to think ahead and to see what are the commonalities when it comes to a child facing a justice system. What are the basic principles that should be applicable? And after a long process done under the auspices of the Council of Europe, and we'll hear about it in a minute, the guidelines were adopted. And what is very interesting to keep in mind is the fact that those guidelines have an effect at the European level, the level of the Council of Europe, but they also are used as model in other regions of the world. The MENA region, Africa, Latin America, all have adopted the guidelines and are using it. And then we had the try to have global guidelines that were drafted by the International Association of Youth Magistrates and Judges. And so we can see that the Council of Europe played a very incentive role in this field and trying to really make justice system a little bit more accessible to children. When we use child-friendly justice, the word friendly is always something that we can discuss because sometimes it's difficult to think that a justice system that everyone should avoid to face could be friendly. But at the end of the day, if we can improve the capacity of the justice system to deal with children, this is probably the most important. To come back to the project, this project started on the idea that in the field of the administrative justice for migrant children, we can see that probably little efforts were made up until now to try to adapt those procedures to the particular situation of migrant children. And we know that they are facing specific difficulties about the language, the knowledge about the justice system, the knowledge about who can help them, and so on. And so we really wanted to look into this administrative justice procedure and system and to see how it is organized at this stage at the European level, and certainly how can we help to promote a better justice system. It has been done through different steps, inquiries, interviews, but also with an important child participation dimension. And I think that Regina, who will talk in a minute, will like it. And this gave an added value to the end product and the realization, the tools that were realized in the frame of this project. So without further ado, I just want to go through the program of the day so that the afternoon, so that you know what you will have on the menu. We will have two panels, I would say. First one looking more, first of all, a keynote speaker who will remind us where we come from and the global picture of the child injustice at the European level. Then a panel which will be a bit more academic and try to understand the principle of the child injustice applicable in this field. Then we will have intervention of people working on the field and to also look at how we can translate these child injustice guidelines from the written word on the paper to the field and an effectiveness on the field, which is at the end of the day, the end. And we will have example on the situation in different countries through the experience of some of the partners of this project. So that's the menu for the day. And so I'm very pleased to give the word and to introduce our first speaker. I don't think that she needs introduction, especially in a webinar dealing with child injustice at the European level, because everyone who works, who heard about child injustice at the European level should know at least the Council of Europe, the Children's Rights Unit, and the head of the Children's Rights Unit, which is Regina Jensdottir. Regina, thank you very much for being with us. You are the head of this Children's Rights Division of the Council of Europe, and in that capacity you are also ensuring not only the adoption but also the following up and the implementation of the children's rights strategy of the Council of Europe. Yeah. And I think that it's worth to remind that this strategy is already probably more than 10 or 15 years old. It's the third strategy in a row, 3 times 6 years, if I'm not mistaken. So we are working on the fourth strategy for the next 6 years. And I would say that the landscape since the beginning has changed very much, and the focus on children's rights is now very lively at the level of the Council of Europe. So thank you for being with us and for giving us this introductory speech to start the discussion on child injustice in action. You have the word. Thank you.
Thank you very much, Benoit, and good afternoon to everyone. Can you see and hear me, Benoit? Can you just nod? Because I can only see you. Okay, good. Thank you. The journey of justice. Well, I think that is actually the title of my presentation, which came up after I'd started preparing my presentation. And I would like to thank Defence for Children International for giving me the opportunity and the platform to really look at the journey that migrant children have to go through to access justice and to be heard in the justice. The moral arc of the universe is long, but it bends towards justice. And this quotation of Martin Luther King really makes me think of the journey that child migrants embark upon to flee injustice, crime, poverty, discrimination, violence. And they leave the comfort of their environment, their countries, their families and friends, seeking a better life on our continent, which we proudly boast as being built on human rights, the rule of law, and democracy. So are they really to blame for taking risks to live a better life? And is it not our responsibility to ensure that our part of the universe leads them to the path of justice? So our moral arc is also theirs, and once they set foot on our grounds, our justice becomes their justice. So why are we still having to discuss this? Why are we still thinking about this? Why are we still trying to find the right solutions? Why are we still trying to develop further guidance? Are we still stuck in that bend where justice is in the shadows, really in the shadows? And we all know that justice systems in Europe are not always adapted to the specific needs of children of any background and in any situation. And I therefore feel that our justice systems have been significantly challenged in the migration crisis or with the migration crisis. So to tackle this issue, and since the adoption of the guidelines on child-friendly justice already 10 years ago, as Benoit already reminded us of, the Council of Europe has produced numerous standards. We've produced reports, further guidelines and recommendations to help our member states really put these guidelines into practice. We have truly not been alone on this journey, that's clear, and I'm very grateful for the trust that key partners such as Defence for Children International have placed in the guidelines, which today are really a brand or a trademark on its own. A brand that we all understand, we all believe in them, and we all trust them. So, adopted in 2010, these guidelines, they have provided us, as well as our member states, as Benoit recalled, with a compass for navigating through the comprehensive right-based criminal, civil and administrative justice systems and processes, including migration proceedings. They apply equally to all children, whether they are victims of crime or alleged perpetrators, or if they're involved in migration processes or procedures, family law, or other legal disputes. So the guidelines were prepared in consultation with about 4,000 children, which was quite new at the time in the Council of Europe that we took that step, and we were considered as being me, Sabrina, and those of us who were preparing the guidelines together with the group of the Council of Europe, we were considered to be, I mean, I see it as avant-garde, but many of our colleagues and some of our experts and states, especially states, they didn't see the point of interviewing children. Why would children need to have a view on the justice system? Which really shows the problem 10 years ago that we had concerning why children would actually be associated with justice at all, when in fact it is at the epicenter of some of the main challenges and problems that children have. But a decade after the adoption of the guidelines, they have now been translated into over 25 languages. They're used as the benchmark by governments and authorities far beyond the European continent. So across the Council of Europe, child-friendly justice has now been mainstreamed and integrated into our work. I don't like using the term mainstream, but it actually illustrates to the extent in which we have in the Children's Rights Division been able to influence other sectors of the Council of Europe to believe in child-friendly justice and to do something about it. The Parliamentary Assembly has adopted a resolution on child-friendly justice. The European Court of Human Rights has had recourse to the guidelines and their principles in numerous judgments. And I think this is really extremely important for us and for our member states and for member states' judicial systems. Achieving a child-friendly justice for all children is a major theme covered by the Commissioner for Human Rights of the Council of Europe, as well as key priority for the Council of Europe strategy for the rights of the child. The guidelines have also been embraced by the European Commission and the European Union in their activities and taken into account when drafting their own standards in the field, including the Directive 2016-800 on procedural safeguards for children who are suspects or accused of persons in criminal proceedings. I also want to acknowledge the commitment of the Commission in really supporting projects and funding projects which are strengthening child-friendly justice based on the Council of Europe guidelines as such. This is something which is quite unique, and I think that all of our participants need to understand the efforts that both of our organizations have placed into making more progress on child-friendly justice based on these specific guidelines. So at the international level, the general comment on the rights of the child and justice systems by the UN Committee, of course, and which complements and strengthens our guidelines and work and is, of course, welcomed. We must recognize that our member states are already working towards the improvement of justice for children. The strategy midterm evaluation process revealed in 2019 that progress in this area has been achieved as states have taken steps, small steps, to decrease the number of children deprived of liberty, to make child-friendly information available to all children, including children in migration. So a small step for children. Is it a bigger leap for mankind? I think we still have to reach that bigger leap area because we are really not making as big of a progress as I would have wanted us after 10 years, even if we have come a long way. But from the adoption of the guidelines, we've been stepping down and really zooming in on more focused operational areas where weak spots are found. And one of these areas undoubtedly is access to justice for children in migration, including their deprivation of liberty, which continues to be entirely in the shadows of our justice systems. The Steering Committee for the Rights of the Child, our pan-European platform for regular exchanges of knowledge, good practices and experiences, supports the implementation of policy measures to protect unaccompanied and other children in the context of migration. And a range of standards and publication is already available in this area. And last year only, the Committee of Ministers adopted a recommendation on effective guardianship for unaccompanied and separated children in the context of migration, and its explanatory memorandum will be adopted by the Steering Committee in 2021. And this Steering Committee, gathering 47 member states, is going to act as the focal point for following the implementation of this recommendation on guardianship, which every single unaccompanied child should have access to a guardian. And we're really going to follow how the states are doing that in practice. Our team has also been looking at the issue of respecting children's rights when undergoing age assessment procedures. And as a result of this work, a guide for policymakers and a report on policies, procedures, and practices was published. The Steering Committee is also in the process of adopting a legal standard on human rights compliant age assessment procedures, which are aimed at policymakers and professionals, and which will be adopted as well in 2021. So we have also published a handbook for frontline professionals on how to communicate with children in migration, and I think that really feeds well into the report and the tools that you have published or publishing in the context of this project. And finally, a few weeks ago, on the occasion of the World Children's Day, EASO and the Council of Europe launched a joint video animation for children on their rights in age assessment procedures, which is already available in 4 languages, English, French, Portuguese, and Spanish. And the Council of Europe will be translating this into Arabic, Pashto, Dari, Tigrinya, Somali, and Punjabi before the end of this year. So we're really trying to zoom in the child-friendly justice lens on children in migration. We've also repeatedly called to end practice of immigration detention of children, and we've published a guide for parliamentarians for visiting places where children on the move are deprived of liberty, together with DCI. We cannot forget to mention the practical guide which we did on monitoring places of detention, and we adapted that then specifically for the parliamentarians, because parliamentarians have a huge role to play and can be real allies in trying to end immigration detention of migrant children. So in this context, and under the auspices of the CDDH, which is the human rights intergovernmental body of the Council of Europe, we have produced extensive guidance on both the legal and practical aspects of alternatives to immigration detention. And we've not only produced comprehensive legal work in the field, but also concrete practical guidance on how to successfully implement alternatives that actually work and protect children. And this and other work is now accessible online in an interactive and very engaging manner through both the help course on refugee and migrant children and the help course on alternatives to immigration detention. So the adoption of strong principles and frameworks for child-friendly justice system is really an important step forward. But the real test of our justice journey lies in their implementation, which is why your project, Child-Friendly Justice in Action project, with the resulting report and toolkit for professionals, comes as a really dynamic contribution to understand how we are shedding the light on good practices and setbacks in state justice systems for migrant children. So let's be frank, despite all the progress achieved, the reality is that children in Europe continue to face difficulties in accessing justice, and European justice systems still present challenges in adapting to the needs of children in European countries, have to expand their efforts to prioritize child-friendly justice in their political agenda. So as your report has found out, the child-friendly justice guidelines are only partially implemented, as in many respects, the child is seen and treated first and foremost as a migrant, which is a major obstacle to implement children's fundamental human rights. The child-friendly justice standards are not yet sufficiently disseminated and known among professionals working with children in contact with the justice system. And this is where I would like to take our new strategy for the rights of the child. Hopefully the European Commission will also put an emphasis on putting them really into practice. We've developed so many tools and projects which really we need to harness it. We need to make them available. We need to pull them all together, because I'm concerned that we will have a lot of reports and a lot of which will not be used by the professionals in our member states. And we really need to be careful and to watch that space. So children experience fear and shame, and they are among the least likely groups to be heard or to have their views taken into account during judicial processes. And children are, of course, not well informed of their rights and the procedure and its outcome. And I congratulate DCI for really being always concerned about having children involved also in any activity that we organize. We cannot find the solution without children giving their views and giving us their expertise. But when they come into conflict with the law or arrive with migrant or refugee status, it is often thought that they can be dealt with by detention. And it is a reality that children in migration are still subject to administrative detention, frequently in unsuitable conditions. And these children who have often suffered from the most terrible of situations. Our justice systems must help them to overcome such trauma, not compound by it. We fully endorse your report when affirming that no child, whether alone or accompanied, should ever be detained for migration-related purposes. There is quite simply no excuse left. Instead of detention, alternative care modules must and can be found and implemented for all children who come into our reach. In this, we already have produced concrete guidance forward. The COVID-19 pandemic, as little as I like talking about it, but it has indeed further challenged to this mix, as it has led to the closure of courts across many member states, provoking delays in children's access to justice and hindering children's contact with their legal representatives or guardians. Confinement and other restrictive measures have sometimes led to a further isolation of children deprived of liberty, which include children in migration. Against this background of this new current reality, it really remains high and possible to ensure that justice systems are child-friendly. And with this objective in mind, the Council of Europe has been and will continue to be active in responding and offering support to its member states during the pandemic. All these major concerns that we've been dealing with over the past 10 years, they appear to have one thing in common: the lack of awareness on the need or the lack of knowledge on how to put the child at the center of the justice procedures. So looking at the future, I can reassure you that the Council of Europe will continue to face remaining obstacles on our long journey for children in migration, and the current strategy for the rights of the child, which is going to conclude next year, will shed lights on the best ways to meet this challenge. In the years ahead, we are ready to support our 47 member states through capacity building and development of further tools and cooperation activities. We are currently, as I said, preparing the new strategy, and child-friendly justice will remain a high priority. A particular focus will be placed on training for legal professionals involving children, on capturing data on children's experience in the justice system, on further promoting Barnahus model across Europe, and supporting community-based legal and paralegal services for children, among others. In the area of migration, further work will be implemented by promoting, of course, the guidelines on guardianship. We will have the action plan for migrants, and of course our new recommendation on age assessment. In addition, legal and practical guidance on family-based care for unaccompanied and separated children will be finalized, showcasing the way forward in implementing better models for better care. And children need justice systems that take account of their special needs. And through the measures already implemented and many more, our aim is to make accessible, empowering, and child-friendly justice a reality across the board. Bringing the issues out into the open and discussing them in a clear, positive, and sensitive manner paves the way for further progress. So I think that this event is really a valuable opportunity to do that. I cannot conclude but by congratulating you for the success of your project, and of course wishing you a very fruitful discussion. I know that my time is up. I'll also to congratulate you, Benoit, on your recent election to the UN Committee for the Rights of the Child. I think that we can all be extremely reassured that we will have a representative in the UNCRC, which is going to inject the right expertise for child-friendly justice and children that have to come into the justice system. So we are very proud and we're very happy that you will be our counterpart in this new role. And of course, delighted that you will still stay with Defence for Children International, because we really count on you. Thank you very much for listening. If there's still time, I would be happy if the new animation, which was produced by the Council of Europe and EASO at the end of November, could be showed to our audience. This is really a child-friendly information video for children about age assessment, which I refer to as being translated. So I would really like to thank you very much for your trust and your commitment always to the work of the Council of Europe, and I'm very happy to have been able to be here with you. And I will stay on in case there are any questions.
Thank you very much, Regina, for this presentation, for your kind words. And I no need to do that, but I would like to reassure you, I will carry on the guidelines with me, and it will be part of my documents of reference in my future mandate. Thank you for also reminding us all the work that has been done, and it's amazing how much has been done. But as you highlighted, still very much is to be done. So maybe, Laurent, we can show the video, because it's an excellent example of what can be done to try to make it more accessible to people, to children, and to continue raising awareness on the guidelines and specific tools. So please share this video.
Can you see the video?
Yes, we can see it.
Okay, I play it.
Hello, I am Tony, and I am a guardian. As a child, you have the right to a guardian like me. I help you express your points of view and make sure you will be heard. As a child, you can go to school and have a safe place to sleep. All children need to be protected. Today I want to explain what you need to know about age assessment, a way of approximately finding how old you are and why it is important to you. When you arrive in Europe without documents proving your age, officers like Paula need to be sure that you are a child to be able to support you. In Europe, a child is a person under the age of 18. But the officers cannot just estimate your age by the way you look or based on what you say. If your age is not clear, officers may ask you to undergo an age assessment. After that, you have a document officially proving your age. It will identify you as a child. There are different ways of assessing the age of a child, starting with the least invasive. 1. An interview with an officer like Paula. She will look at documents you provide and ask questions about your story. 2. Meeting a child psychologist like John, who asks general things about your life. Or 3. A physical exam by a doctor for children, checking your body, your weight, and maybe teeth. During the medical exam, there is no need to take off your clothes. If asked, you can just say no. Normally, you can choose your doctor to be a woman or a man if they are available. They might want you to take a picture of your bones. This is called X-ray. It is not painful, but it involves radiation, so it's better not to do it often. If you feel uncomfortable or you have questions, please ask. Another important thing, the results sometimes can make you a bit younger or older. When this happens, the officer should use the younger age as final. If you think that the officer, psychologist, or doctor were wrong, there are ways to contest their decision. Always share what you know and say when you don't know something. It's okay. I will be there to support you during the process and help authorities to decide what is best for you. We call this the best interests of the child. Remember, speak up and ask questions about all you want to know, not just on age assessment.
Thank you once again, Regina, for sharing this video and this tool as one example of the many tools that exist in this domain. And I think that...
Legal. Por seres uma criança, tens o direito.
Okay, there was a noise, a background noise. And I think that, yeah, this is an excellent example of a tool that really wants to reach the audience, the children themselves, and done in the way that hopefully they will understand, especially if it will be translated in so many languages, which is very important in this case. I didn't mention in the beginning, but I say it now, this webinar is recorded, and we will put it online afterwards, so that people who had not the chance to follow it live, they can still have the content afterwards. There will be a report made of this meeting, and finally, don't forget that there is a button on the bottom of your screen, question and answer, so you can ask question through that chat. It's different than the one on chat, so please use that button if you want to ask a question or to share a comment. Now I will give the floor and open the second panel with first of all a presentation of the project itself, Child-Friendly Justice in Action. I will give the word to Laurent Beauthier, who is, works for DCI in Belgium. He has a training double degree in translation and international cooperation, and he works for DCI-Belgium since many years now. He works as a coordinator of many international and European projects. For instance, he did the coordination of the project Children's Rights Behind Bars, away, or now Child-Friendly Justice in Action. So I give him the word in thanking him for all his work and in investment in this project, and now it's the time to get to know a bit more about the project itself. Thank you, Laurent.
Thank you, Benoit. Thank you very much, Regina. Thank you to all of you for participating in this event. So I will share my presentation right now. And you can see it, I think. So my presentation, it's divided into two parts. I will go briefly and explain to you the background, some background information on the project itself, and then I will go and tell you a bit more. I will focus more on the European report, which is one of the final outputs of the Child-Friendly Justice in Action project. So, okay. Child-Friendly Justice in Action, it's a project funded by the Erasmus Plus program. And the main objective, as you may already understood, is it's about to enhance the respect of the child-friendly justice principles within the administrative justice procedures. But it was also, and something that we haven't mentioned yet, the first step towards the creation of a brand new network on child-friendly justice. So this is really the first initiative bringing together some members of this brand new European network, and we hope that there will be other opportunities, of course, to develop this network. The main focus is on migration-related administrative proceedings involving children. So it lasted 2 years. And the partnership is as follows. So all the European sections of Defense for Children International were part of this project. And the coordinator is Defense for Children International Belgium. So how did we work really? The methodology is based on a bottom-up methodology. So during the first year of the project, we went into contact with the youth worker working in contact with children. So the people working in the administration and dealing with the international protection applications involving children, whether they are accompanied or unaccompanied. Actually, only in Belgium, we focused our work on accompanied children. So we developed specific questionnaires, and we also interviewed professionals. And during the second year, we really wanted also to have the opinion of the children themselves. So we organized participative workshops with children, and we wanted to get to know to which extent exactly do they know their rights, do they know the child-friendly justice principles, but also the experience during the procedures that they went through. And it was the same for the professionals. Of course, we wanted to get to know to which extent do they know the child-friendly justice principles and how do they apply them in their daily work. But also we made some desk research. And so at the end, each partner developed a national report, and based on that national report, we developed the European report that I'm going to present to you in a few minutes. Vanessa, my colleague working also on this project, coordinating this project with me, she will present to you during the second panel discussion the practical toolkit. So taking the recommendations and all the work that we've done and the findings that we have made in our European report, we developed a practical toolkit, something really concrete for the professionals to help them to actually implement the child-friendly justice principles. We also developed another document, which is the document called Voices of Children, bringing together some of the quotes of the children that we've met during this project. But you will see also some quotes in my presentation of the children, but also of the professional that we've met. So the European report, first a quick introduction, then I would like to show you the key challenges that we wanted to point out in our European report, taking into account the situation in the countries involved in this project, and some main recommendations. So yeah, the context, as you know, and this is also according to UNICEF, there are millions of children each year who interact with the justice systems. But the fact is that the justice systems were not originally designed to meet this part of the population needs and requirements. Lengthy procedures, difficult terminologies, or also stressful environments are usually the kind of descriptions that are used by those people, the people in contact with justice system. And this is the opposite that should be of the qualifications that should be used by them, especially for children, of course. And according to Eurostat, there are 200,000 children who seek asylum in the 27 member states in 2019, which represent 1/3 of the total people seeking asylum in the European Union that year. So you can imagine that's a lot, and that this is why we think that it's really important that the procedures are adapted to children. So I won't go too much into details to explain to you what are the guidelines of the child-friendly justice, but this is really the reference of our project, and it's a really important tool if we want to implement better and more adapted justice for children. So it is inspired by many international standards, International Convention on the Rights of the Child. And what is a justice which is child-friendly? You can see here in the screen that this justice must be accessible, age-appropriate, speedy, diligent, and you can read my slide. According to us, according to the project, are the migration-related procedures child-friendly? And as Regina just said, yeah, that's one of our conclusions. is that generally speaking, in all partners countries, the guidelines have been found to be only partially implemented. In many respects, the child is seen and treated first and foremost as migrant. And this is a major obstacle, of course. And now I would like to draw your attention to the main challenges among the child-friendly justice in action partners countries that we pointed out. And yeah, there is no real order, but the first one is about age assessment. That's one of the major issues highlighted by the project partners, which is actually the real reliability of bone tests. And as stated by the European Asylum Support Office, there is no age assessment method that can provide accurate results on the chronological age of the person. Therefore, this lack of accuracy prevents this method to be considered as valid. Nonetheless, the method continues to be used as a reference for age determination in several countries. So we have to be aware that when he or she is not recognized as a minor of age, a child may face harsh consequences, such as the exclusion from social protection, from the right to education, and from reception facilities. This can lead to the disappearance of unaccompanied children who may end up in a context of social marginalization, such as in the streets, for example, in Athens. Another challenge that we wanted to point out in our report is the speedy and diligent justice, this balance that we need to find. It is important that the time allowed to the asylum seeker to start the procedure or to appeal is dissociated from the time limit when within which a file is processed by the administration. So that there should be enough time for the asylum seeker to recover for an often traumatic journey, get prepared for the interview with legal support, and to appeal when relevant. For example, the Netherlands National Report of the Child-Friendly Justice in Action has highlighted that the interviews were taking place too early in the Netherlands, and a period of 10 days, as provided for in Greek legislation, is very short for the child to appeal. So, but on the other hand, the time limit within which a file is processed by the administration in the European countries targeted can take up to 2 years, and even more in case of appeal. For example, in Italy, the procedure can be extended from 1 to 2 years in case of appeal. Another challenge is about, of course, child-friendly information. Children involved in an application for international protection in the countries targeted in this report seem not to be well informed about their rights, the procedure, and its possible outcomes. As it is the case in Greece, for example, the lack of information on the right to family reunification and the rights of the child is a major obstacle to the exercise of the rights of the child. So here we have a quote, for example, of one of the unaccompanied child that we met. You can read it. So the first time I had information about asylum was when I attended in the information section of DCI. I was visiting a youth center that time so as to eat and wash my clothes and attend some activities. Nobody else informed me about anything. I was homeless and unregistered for months after I arrived in Greece. I did not even have access to the international protection procedure. I was an invisible person. So this is really to illustrate this finding. Another important thing is the right to be heard. With regard to participation, research shows that 2 elements. Children are not given the opportunity to participate, or when they are heard during the process, poorly adapted processes have negative consequences for them. So in Belgium, for example, it's common that if an accompanied child is considered to be too young, participation is automatically excluded. Yet a child should not be prevented from being heard simply because of his or her age. And here is an illustration of what we can do actually from a lawyer that we've met here in Belgium. So this week I went to the immigration office with an unaccompanied child. She was 8 years old, so we were sure she wouldn't say anything. She told us 1,000 of things. She even defined xenophobia for us. It was unpredictable. Another key challenge is the lack of appropriate training for professionals. And a lack of mutual knowledge and coordination between the various professionals is noted as being sorry, no, I just, I went too fast. So the Child Friendly Justice Guidelines lay down that all professionals working with children should receive interdisciplinary training on the rights and needs of children of different age groups. And here is also an illustration. I wanted to apply it for asylum, but my social counselor told me, you will be able to do it at 18 years old. She didn't know that I could do it before and even without my birth certificate. So another finding in this category is the absence of child-specific frameworks and guidelines. There is a lack of internal guidelines to adapt procedures to the needs of children in most of the administrations. And for example, we met also in Belgium a litigation judge, and this is what she told us, that for her it's a bit like searching and experimenting, because there are not really any guidelines that I can rely on. By reading cases from other countries, particularly England and the Netherlands, I try to find ways to conduct hearings in a child-friendly manner. We also pointed that there is a lack of knowledge and training on the child rights, on the Convention on the Rights of the Child, and also on communication and child psychology. So another key challenge that we pointed out is about the lack of cooperation. So a lack of mutual knowledge and coordination between the various professionals is noted as being, in some respect, a major obstacle as well. So it appears that some information is not provided because these different professionals believe that the information has already been provided or will be provided at another stage of the procedure. Another challenge is about the lack of specialized professionals. So, for example, about cultural mediator or interpreter, case workers, guardian, and legal aid. For example, one single guardian is often in charge of a big number of unaccompanied children, which makes it very hard for him or her to cover all the needs of a child, and many children are left on their own. Regarding the legal aid, in several European countries targeted in the project, no state-funded free legal aid is provided under law at first degree. That means that children who are not supported by an NGO are not legally represented. And another challenge that we noticed, it's the administrative detention, of course. And as we can see, a large number of children are still detained in conditions that do not respect their fundamental rights as children, and sometimes for long periods of time. So this is sometimes due to structural reception problems, but also sometimes to political decisions, contrary to international commitments. And finally, there is a lack of appropriate accommodation. The lack of housing adapted to the specific needs of children is noted in most of the targeted European countries. Lack of adequate structures compromises the fulfillment of the European standards of reception. For example, in France, the lack of places in some departments leads the social services to place unaccompanied children in hotels where educational support is almost non-existent. So these are the challenges, and now I would like quickly also to draw your attention to some of the recommendations. I won't be able to list all the recommendations, and I invite you to look at the European report for all the details. As you can see, the main recommendations that we have are divided into 12 categories, and I will just mention a few of them. Like, for example, about child-friendly administrative procedures. It is essential to ensure that in practice the implementation of these procedures complies with the child community justice guidelines overall and at each stage. Therefore, beyond the legal framework, implementation tools must be developed as well as regular monitoring ensured. For example, regarding the chapter legal counsel and representation, the Child Community Justice in Action research shows that in many ways, children involved in migration-related administrative justice procedure do not have adequate access to legal aid. Therefore, one of our recommendations is to ensure that children are assisted by a lawyer or legal advisor free of charge from the beginning of the administrative procedure and at every stage. And just to conclude, no child about the detention, no child whether alone or accompanied should be detained for migration-related reasons. Such detention is indeed contrary to the CRC. So thank you very much for your attention. All these outputs will be available on the Child European Network on Child Community Justice, but also on each partner website. Yeah, thank you for your attention.
Thank you very much, Laurent. I think that we have a good overview on what has been done during this project. We will go more in details for other dimensions of the project, but without further ado, and we are a bit beyond schedule, I will give immediately the floor to Isabella Athanasiou. And she will try to respond to the question, what are the obstacles to a procedure adapted to child migrants? We have already heard some of them. And how, and this is probably also more important, how can these obstacles be overcome? Isabella is working as a legal officer at the asylum unit of DG Home of the European Commission, and she coordinates the work of the protection of migrant children at the level of DG Home. She's responsible for the monitoring and the transposition and implementation of the Asylum Procedure Directive, the 2013 directive, and is the coordinator of the infringement procedure against member states on the asylum-related matters. So she's very well placed to have a global view on the rules applicable at the European level, but also how the national states do apply those rules. So thank you very much for being with us this afternoon, and you have the floor.
Sorry, I didn't unmute. I hope now you hear me. Good afternoon, everybody, and thank you very much for inviting me to this roundtable. I was listening with a lot of interest to the 7 main findings that were previously presented by our colleague Laurent. And I think he has already in 7 points simplified my work, because one of the aspects of my intervention was to identify what is that doesn't work. So I think that those 7 points are pretty much covering every angle. I can try to develop a little bit on the second part instead. What can we do to improve the situation? So here what I wanted to do is, but before going to discussing the second part, before I forget, what I wanted to say is that these findings, when I was listening to them, I was thinking to myself, how interesting that it's basically the year 2020. And we are arriving to the same conclusions that brought us to adopt the 2017 communication on the protection of the children in migration. And this is a sign that many things have still not been solved the way that we were recommended to solve them in the 2017 communication. You probably, many of you know because you are familiar with the document, but that was a very in-depth diagnosis at every stage of the migratory project of every child. So starting from their country of origin, going through the hurdles of transit countries, and then the problems that start occurring upon arrival in the EU and until a status is being determined for the child, be it for being allowed to stay and integrate, be it the perspective of being returned. And in that context, many of the things that have been flagged in the 7 points of Laurent were actually flagged at that moment in time. Now, it is also fair to say that some progress has been made on certain accounts. Some member states have made quite impressive progress. I mean, just to give an example, the example of Italy, who we, in the meantime, at the time of 2017, the situation was pretty stretched in Italy in terms of resources, of capacities, of guardianship, of a series of issues, including access to the procedure, many things that have to do with access to justice, right? But the country has reformed its guardianship system. It has a very interesting, genuinely innovative model that involves voluntary people who are working to support the children. It has its own particularities. Not everybody can do the same in Europe, of course, but it is interesting to see that it has been so far doing pretty well. It's not the only country that has worked on reforming its guardianship system, and some other countries have also allocated more resources to the recruitment and the training of guardians. There is also by now on feet the embryo of a future fully fledged European guardianship network that is in place. So the project is managed currently by NIDOS, which is the Dutch guardianship agency. It's an independent body in the Netherlands. And they are managing the project at the European level with financing currently from DG Justice of the European Commission. It is not yet, how should we say, a network where decisions can be taken together and new projects can be determined. But the membership and the nature of the functioning of the network are work in progress. So we are going to see how this project is going to develop for the future. And now I wanted to come to the second part. The question that has been addressed to me was what can we do to address the identified challenges and the gaps in terms of child-friendly justice. And here what I do not pretend to have the answer to this question as a full, but what I wanted to say is a couple of remarks about what has been tabled already in terms of proposals in the context of new pact on asylum and migration. And then we can open the discussion and see what people think, whether they are addressing suitably the identified problems, whether there are still gaps or not. I am not going, for reasons of time and the nature of this event, I'm not going to go into a fully fledged presentation about the pact and all the legislative proposals. Just wanted to mention some of the elements in those proposals which are relevant for the protection of children and where an effort has been made to strengthen actually the legal guarantees that are available to children in the context of asylum and return procedures. And I would start with perhaps one of the most important and relevant one to our discussion today, which is about guardianship. So in the proposal for a reception conditions directive, for the new reception condition directive, and I'm referring now to the text that has been politically agreed between the co-legislators in June 2018. So not the original proposal from 2016. In the meantime, elements have been introduced into the text. But the text as it stands as of June 2018 contains some important elements of novelty in terms of guardianship. First and foremost, there would be precise deadlines for the appointment of the guardian. So as opposed to the current status quo, where we have provisions of European law which call for the appointment of a guardian for the unaccompanied minors as soon as possible. It's the quotation from the legal text. In the future, if this text were to be adopted, we would have deadlines of maximum 15 working days from the moment of manifesting the intention to apply for asylum for the particular context of the tasks that have to be developed in relation to the reception condition directive. So we are talking about access to the rights of the applicant, if you like. So we're talking about accommodation, we're talking about access to education, healthcare, and so on and so forth. When it comes instead to the procedures, that comes under a different text. So that is the proposal for the asylum procedures regulation. And in that context, the deadline that is currently proposed on the table, we will see how it evolves in the context of the negotiations, is actually 5 working days, not 15. So you will see that there is a little bit of a discrepancy between the two. We don't know if this discrepancy will survive the negotiations or not. It is possible, everything is possible. You could even end up with 2 different deadlines. But it's in such a case, I mean, logic tells us that, I apologize for this, there was a sound on my mobile. In that situation, I would believe that logically a member state who decides to have one single person, one representative, one guardian to perform both sets of tasks, meaning both related to the procedure and also to the reception condition system, in that case, probably logically the shortest deadline applies. It's also relevant to say that the proposal for the asylum procedures regulation foresees for a shorter deadline because the needs are a little bit more immediate, so to speak. So basically, in theory, we are thinking that a guardian should be appointed for the person declaring themselves to be an unaccompanied minor from the very moment of identification and registration. So before even the data is introduced into the Eurodac. And particularly in the future system where we will have a pre-screening procedure and then to be followed by streaming the migrants into 3 different kind of procedures, it becomes important to be assisted if you are a child in a phase where your future is being determined in terms of being either going into the normal procedure because you are recognized as an unaccompanied minor, or that you would go perhaps in the border procedure or even the return one if you don't apply for asylum. So the presence of the guardian, this is probably the main sentence that I wanted to express, is that in the future system where we are heading for speedier and more effective procedures, it is furthermore important to have the assistance of a guardian as soon as possible and to be properly assisted by the guardian. So this is why there should be also systems for monitoring how the guardians perform their task. There should also be provisions for the training, so for boosting the qualifications and the staff of the guardians. And these are aspects which are a little bit more developed in the reception conditions directive proposal than they were in the current version of the directive. We have also heard about age assessment numerous times today. Obviously, the presence of the guardian is of paramount importance in the context of the age assessment procedures as well. And also, just to mention very briefly, as you know, we are supporting the member states in applying and following the ASO guidelines on the age assessment procedures. And the recommendation is in line with what was previously mentioned by the Council of Europe. So basically, we are telling the member states it's not recommendable to jump immediately into invasive medical examinations, but to try to take a gradual approach to see if other methods can be used first, which are less invasive, including medical if needed, before arriving to radiation and the likes of it. And obviously, when it comes to that, I mean, if you, for example, are a country like Italy, which has introduced a holistic methodology for age assessment, which involves a panel of specialists of different types, the presence of the guardian there is crucial, of course, again. Another thing that I wanted to mention is access to justice. In terms of access to justice is the right to be heard. We heard about this before. I wanted to basically make a little bit of a distinction between the right to be heard at the judicial stage of the procedure and the right to be heard at the initial administrative phase of the procedure, if you like. Not to say that they are not the same right, they are the same right, but it manifests and has different consequences in function of the stage of the procedure. We heard previously from the colleague Laurent, who mentioned that in Belgium sometimes courts do not call children who are under the age of 12, for example, because they think that they are too small to express their views in a court hearing. That shouldn't impede hearing the views of the child. So even if the thing is not a formal procedure, a formal hearing at the judicial stage, but in the administrative stage, there are interviews and there are other ways of having contact with the child, not in the least the best interest determination. And in that context, it is a paramount of importance, again, to hear the views of the child, according to the degree of maturity of the child, according to age, and so on and so forth. But it needs to be like that. The right to be heard is the proposal in the new pact and the new legislative proposals perhaps are not very explicit in creating new language in terms of the right to be heard. But it is implicit in the system that there is a right to be heard, and it is being reconfirmed in the context of the reform. I wanted to say a couple of words about detention as well, because that has also been mentioned again.
May I ask you to conclude in 2 minutes? Is it possible? Even one, if you like.
Yes, last words are about detention and alternatives to detention. Again, an acknowledged common problem. I do not need to dwell too much on the fact that, as you know, there are some member states who are more resistant to the idea of a complete ban of detention for immigration purposes, not because they are thinking so much about asylum applicants, but probably because their main concern is about the return of families with children, families who have been subject to a return order. And basically here, this is going to be a difficult discussion. The current proposal of the Reception Conditions Directive reinforces the exceptional character of detention and calls even more explicitly, if you like, for the creation of alternatives to detention, effective ones that work in practice, but that would be basically, to sum it up, a way to go forward is to work together on creating effective alternatives to detention. And this is where I will conclude. Thank you very much.
So thank you very much, Mrs. Athanasiou. Thank you for giving us this overview also on the project, the discussion going on, which are extremely important. It's a pity, to be frank, that the directive still foresee the possibility for children to be detained in the frame of the asylum procedure and all the migration procedures, because we know also that the international community more and more emphasize the importance to ban completely all detention of children for migration reasons. And so I hope that the European Union will show the model and the example to other regions. And this is our hope and what we are also working on. So thank you for all this presentation. And then I will give the word to Marieke van Buggenhout. She's criminologist in Belgium and works since 2015 in the Department of Criminology of the Vrije Universiteit Brussels. And she's also a member of an interdisciplinary research group on voicing youth at social risk. And working in different fields of research on migration, minorities, and other related topics. She's currently researching on the asylum procedure visible by observing asylum interviews with young asylum seekers, which is certainly very interesting. And so again, the question is the difficulties and the problem. We have already heard quite a lot on that, but what can we do to overcome those difficulties? So thank you for taking part to this meeting and sharing your experience and expertise.
Thank you very much, Benoit. Can you hear me all right? Yes?
Not that loud, but maybe a bit louder, but it's otherwise it's okay.
I will try to speak a little bit louder then, because I hope my microphone works properly. Okay, thank you very much for introducing me. That means I don't have to introduce myself anymore. Let me see if I can quickly share with you my screen. Okay, cool. Just making sure I have the right. Okay, I'm sorry, I had some problems. If everything goes well, you should see my screen at this very moment. So indeed, I'm also here to talk about some of the obstacles. I think we've heard already a broad reflection on that, but what I would like to do is take you with me and really zoom into a very specific segment of the administrative procedure that minors go through, and it is the asylum interview. My project, and as you mentioned, our intention was to observe asylum interviews with children, but we weren't able to get access to the asylum hearing for children. So what I will talk to you about today is exactly how children form their views and how children are being heard in this procedure. And I draw from that for in-depth interviews that I had with both legal guardians as protection officers and a lawyer. That was our best alternative to actually observing the asylum interview. And my main goal is to talk to you about some of the tensions that exist between, on the one hand, a children's rights approach, as we have already heard and mentioned before, and the intrinsic goal of the asylum interview, which is in the end assessing credibility and making a decision on an asylum claim of children in the procedure. So first of all, the asylum hearing in Belgium happens at the CJRS. It's the Commissioner General for Refugees and Stateless Persons. And during this interview, children need to tell a story. Many people, but children especially, have difficulties with that and are possibly limited in the way they can express themselves in the asylum procedure. But we all know minors undergo the same procedures as adults. So therefore, child-specific provisions have been embedded in both Belgian as international law. And as you can see in the picture here, in Belgium, that means that a child, for example, is being heard in an adapted hearing room, but also by a specialized protection officer, someone that followed an education on how to deal with children, how to interview children. And the protection officers I talked to also state that it's their most important goal to create a comfortable environment for children. So we see that these provisions find their way into practice, while at the same time, protection officers always tell us as well that they struggle to align these approaches with the stated goal of their job, which is still in the end to collect elements and to make a decision. And in order to share with you some of the findings, I would like to use a metaphor that has been used by not just one, but several of the people that I talked to, and is the comparison of a hearing as an obligatory exam, with all the results of that children also feel very stressed to undergo this procedure. So people have described to me this moment as an ultimate test that everything stands or falls with. And with that difference that a child either passes or fails the exam, but this has life-changing consequences. That is the reason that the asylum procedure and the hearing is seen as the ultimate chance for a child to narrate about the reasons for claiming protection, but also, and what is interesting here, and it's quite different from police interrogations, for example, children have the duty to collaborate. They have the responsibility to give the CJRS all the necessary elements of proof, even though in spirit of Article 12, a child should have the choice and is not obliged to exercise their right to be heard. So I think that's a particularly interesting thing in this segment of the procedure. And when a child enters the interview, legal guardians explained to me that children must not just learn how or just learn what to say in the interview, but also how to say it. And they must, in other words, learn to speak the language of the procedure. And it has to be done in a way that's detailed, in a way that's consistent, coherent, and above all credible. So as this protection officer describes here, they need to have the feeling that the child really lived the experience and that what he says happened to him is true. At the same time, research such as, for example, the UNHCR report on assessing credibility in children's claims has reported that stress levels are very high because children must endure this test at all costs. And this can, of course, influence the coherence and consistency of a story. So again, linking to an exam, a key element is the way in which a child is prepared for this crucial moment. A student must study for an exam, must be prepared for an exam, and this turns out to be no different for children entering the hearing room. So legal guardians I talked to mentioned that there's differences in the way they help a child to go through this process, and at the very base of the preparation is to provide information to the child. What is this asylum hearing about? What can you expect? But also they have to gain trust of the child, not only to create a good relationship, but also to help a child to discover this asylum story step by step. A child doesn't always know exactly why he or she fled the country. That means that there's a search for information in contact with family members, if possible, a search for official documents, proof, and also often the discovery of a timeline. Yeah? But some legal guardians go even further and say that they actually rehearse the narrative with the child. And this happens sometimes together with a lawyer. This preparation might, with all the good intentions, have a negative effect on the subjective part of the decision-making process of a PO. So as you can see here, on the one hand, it's possible that the child feels the need to fill out certain gaps, and that a child rehearses the narrative and to learn exactly how he or she must talk in the procedure to be credible. And this can sometimes come across as a situation where a narrative is not authentic or might even feel borrowed, as explained here by some protection officers. If I have the next slide, okay. So I will try to sum up to also leave some room for discussion, but I've tried to use the metaphor to show you that the practice of assessing children's claims for national protection is indeed complex. And the right to be heard might also come with some difficulties and possibly some perverse effects for children in this procedure. So on the one hand, we have child-friendly approaches, as I showed before. They have really found their way into the actual daily practice in the asylum hearing. But these results, and they're still very preliminary as we're in the middle of analyzing the data, but they also show us that protection officers struggle to line up this child-friendly approach with what is expected of them as examinators who have to take a decision at the end of the day. And I think it links very well with how this event started, that children are still treated first and foremost as migrants who have to be assessed for their status rather than child in the procedure. Another thing is that indeed legal guardians devote a big portion of their time to help a child to learn the language of the system, not just what they have to say in the procedure, but what is expected of them, to learn to talk in a detailed way, sometimes about very difficult situations. And this begs the question, what happens to accompanied children who are not automatically pointed with a legal guardian? So do they have to endure this procedure alone, and how are they being prepared? So paradoxically, I think it's safe to say that it's not so much the request for international protection that's always scrutinized, but rather how well a child can tell a story. So I think we can see that the right to be heard comes with some obstacles, and that the responsibility on the shoulders of the child to orally testify and to provide evidence can at times be unbearable. That's why there's a need for children to have their views heard also in light of academic research. I'm very pleased to hear that this happens in the project that Laurent talked about, and it's also what we hope to do in the next year of the PhD project, to include children in a collaborative way. So I hope I'm still a little bit within time, but those were my my reflections, and to come up with solutions. I think it's at this point very difficult and too ambiguous for me to say, but I think it's interesting to first understand the tensions that are happening in these practices and to really zoom into these moments in the procedure.
Thank you very much, Marieke. Very interesting. It's a pity that you were not allowed to observe the interviews themselves, because I think that it would say a lot, but yes. I know that this is challenging, and it's usually very difficult to have this kind of access, although I think that it would be extremely valuable just to learn more. You mentioned also that for accompanied children, the situation is probably different and sometimes even more difficult, and this is something that came out of the project too. In many countries, partners had a look more into the situation of unaccompanied minors who are facing specific challenges. But what is the situation of accompanied minors in the procedure? It's also an important question because usually they're not heard, and it's the parents that are going through the procedures. It's time for questions, so I remind you that you can use the question and answer button on your screen. We still have a few minutes before having a break to exchange on the presentation. I have one question coming from Eva Gagneux, a colleague from DCI-Belgium, to Marieke. We have heard that some unaccompanied children had their CFJ-IA interview by video conference, Zoom or other software. This seems to be a practice that is developing during lockdown and beyond. Have you heard about it? And can you give us your impression on such a practice and its influence on the right of the child in question? And I think that more broadly, we see that even some courts are using video conference to hear the claimant or to hear the people, and it will change the relation between the person and the court and the authorities. And so have you heard about it, and have you some thoughts about this specific issue?
Mm-hmm. Yeah, I think it's indeed one of those things during the lockdown that are they have to happen also in this line of the procedure, because children, of course, don't want to see their procedure go on hold and have to wait for months before they can have their audience, their interview at the CJRS. I think something that I've also noticed, but it went beyond the scope of this presentation today, but the actual dialogue is very difficult between a protection officer and a child, because the protection officer at this moment still takes notes, literal notes on a computer. There is the plan to have audio-visual recordings, but at the time I did my research, this wasn't there yet. And this means that it also goes through the interpreter. So there's not really a dialogue. There's a question, there's an answer, but a child has a lot of time where there's a silence and where the child is constantly thinking about what is going to be the next step. So I think a Zoom conference might also be negative in the sense of having a dialogue. At the same time, when the interview is recorded, it would allow for the protection officer to be much more engaged with the child and to have a conversation that's much more a real dialogue instead of an interview. So that's my first, but it's very good that you highlight this, because it's a new recent development in light of the COVID lockdown. Yeah. Yeah,
indeed. So thank you for showing those pictures of the child-friendly room that is used by the asylum authorities. By the way, I mentioned that we have a video presenting this child-friendly room that will be put on our website in a few days. So it will give you more insight on how it looks like. I have another question, but this time it's for Isabella, and it comes from Manon Danger. I have a provision relating to unaccompanied minors are now spread across several instruments in the European legislation, Do you think that a single instrument specifically reserved to unaccompanied minors is conceivable in the coming years? Please, Isabella.
Yes, it's not a new question, actually. This idea has been discussed for several years, I think, now. Personally, I do not see it impossible in the future. Certainly, it's not on the table right now. So,
okay, and in your opinion, would it be an improvement to have everything gathered in one specific place instead of having pieces here and there? Would it be an improvement or a clarification for the public?
well, to the extent that it would codify all the rules that are pertinent to the unaccompanied children in one single instrument, it could be useful for the practitioner for sure.
Mm-hmm.
Would it be a life changer? That's another story. Yeah? I mean, it depends on what is inside the respective instrument. Yeah? If we're talking about the same kind of rules, but just bringing them together, obviously there is added value for the practitioner, no more confusion, more transparency if you like. But I'm not so sure it's a game changer. Huh? So
and sometimes less contradiction between different instruments.
That is possible. That is possible. Yes, indeed. But I have to say also that in full fairness, there is already an effort to eliminate contradictions between. I mean, one of the things I mentioned before is still contradictory, the deadlines, but yeah, I mean, otherwise there is an effort that is being done to have a consistent and coherent view across the instruments. So.
Thank you. I have another question and I missed it. It was just before the other one from Anne Maas, who agree on the fact that the child should be seen as a child in the first place and not as a migrant. But do you have concrete suggestion on how to realize this goal? It's an excellent question, I would say, but indeed difficult because the child still goes through all these procedures and so on, and live or experience it as an exam, as you said. And at the end of the day, we should just forget about the fact that it's a migrant and treat him or her as a child, but the context doesn't help that. If Marijke, you have some suggestion on that, and Isabella, if you want also to intervene, or Regina on this topic, maybe you have also ideas. Marijke?
Yes, I wish I would have a clear answer to that question. I think it would be easier if we had. What I do think is that the children's rights framework has become more and more sophisticated over the past decade and more, and that we see that these elements are slowly but surely finding their ways. And I think that when I look at the Belgian procedure and the way children are being heard, and I'm quite impressed by the way protection officers talk about the way they treat children and how important they find their well-being. So I can definitely say that there has been a long way already dealt with this. But at the same time, they are still in an adult procedure where they're not really treated much different than adults. Children can also be sent back when they're above 18 years old. Children have to learn how to talk in the exact same way, even though there's a liberal application of the benefit of the doubt when a caseworker has doubt. We still see that most negative decisions are based on a lack of credibility, just like in adults' cases. So it's very difficult to almost artificially implement a child-friendly environment in a broader environment that's not very child-friendly. And I think for me, that's the biggest tension that we are facing today.
Yeah, maybe linked to that, there is another question before giving the floor to other speaker. But Sarah Lembrechts from the KEKI, I think she works for the KEKI, if I'm not mistaken, or she used to, ask, do you know anything about the training protection officer receive for doing the interview with children? Is there an element of a children's rights perspective, or is it all about how to obtain facts? I think that you answer a bit of that, but what about their training?
Yes, it's a training from the EASO interviewing children, and it's based on child witnesses, so not necessarily on asylum seekers. So it's a training that is really focused on how to deal with children and not so much how to extract information. I also did not have access to the internal documents of the CGRS, so I'm not really sure on the general education of protection officers and how to get information. So at this moment, I can only listen to what protection officers tell me, and there is indeed some techniques on how to assess information, but I don't know about how this is being dealt with in the education.
Thank you. Maybe if Isabella has anything to add concerning the tension between treating a child as a child and not a migrant. It's a difficult one, and it comes back all the time. And then there is also another question for Isabella. Is there still room for negotiation regarding the new reception condition directive as to ban the detention of children as a whole?
Yes, I will start with the second one before I forget. So yes, there is still room because the text has not yet been adopted. It is provisionally on ice, so to speak, while progress is being made with the rest of the instruments. But of course, it has not yet been adopted. The negotiation is not closed formally.
Yeah.
What I wanted to say about the child being a child, of course, we are all of us acutely aware of the fact that migrant children are sometimes treated differently just for the fact of being migrants. This is why, in the context of the forthcoming EU child rights strategy, which is being prepared by DG Justice, and also of the EU child guarantee, which is prepared with the lead of DG Employment at the European Commission, these are two EU policy frameworks where our intention is to include, obviously, migrant children on a non-discriminatory basis, so they should benefit from the same kind of support and rights like the EU nationals' children, while acknowledging that to achieve the same kind of protection, they may need some extra support in certain circumstances because of the migration background. So I think that this is one way of going forward. I mean, one way of not singling out the migrant children and creating a separate policy for them as well, but to create a comprehensive child policy where the migrant children are treated the same like the rest.
Thank you very much for these complementary information. We have a question concerning alternatives to detention, on which we can come back. Then a question to Laurent about statelessness determination procedure. I'm not sure he has information on that because I'm not sure the project did cover this. But before coming back to the alternative to detention, I would like to ask Laurent if he has any highlight on this statelessness determination procedure coming from Khadija, the European Network on Statelessness.
Yeah, thank you, Benoit. No, actually, the project focused on the international protection applications. So we didn't really explore much more into details other kind of applications or situations.
Okay, thank you. But in fact, statelessness recognition is also an international protection because being stateless is a way of being seen as vulnerable in many ways, because that means that no state in the world can has the duty to protect you. So that's certainly something that we can look at more precisely in the future. What about alternatives to detention? Alternatives to detention is a huge topic. It's a very complicated one. I know that in Belgium, since many years, there is some experience with return houses that are presented as alternative to detention. But still, is it an alternative to detention or an alternative way of detaining people and, in fact, children? Does any of the speakers have anything to say about this? I also know that the Council of Europe is working on the issue of alternative to detention, and there has been some working groups and some action in this field. So I don't know if someone can add something about it. Marek, did you? Is it something that you had the chance to look at during your research? Not especially. At the level of the EU, the Commission, is there any? I know that this is also something that is promoted by the EU because it seems to be a good way to reduce the level of detention. But is there? Do you have any concrete presentation or concrete example of alternative to detention? Isabella, you have anything to add on this?
Yes, actually there are examples, and I think that some of them are actually coming from Belgium. So I have had the opportunity to listen a couple of years ago to an interesting presentation made by somebody from the Flemish government who was presenting a community-based alternative to detention for families prior to their return to the country of origin. So basically it consists of placing the family and the children in a sort of social housing. So it's a house provided by the authorities where they are probably not even having to pay rent. These houses were available because I understand that they were already constructed at the time for police forces, but they were not used for that purpose, so they became available. So in this village, they were placing families in this kind of housing, and the children, while waiting for the return procedures to take place, the children could go to school, like in a normal context. And the authorities were helping the families to prepare the return to the country of origin. Mm-hmm. So going a little bit beyond the paperwork and only the fact of handing in some money so that they can use it when they go back, but basically preparing containers so that they could take their stuff back and transport them to the country, preparing contacts for reinsertion in the community when they arrive in the country of origin. And this kind of support, which makes return a little bit less violent, if you like. And therefore, it reduces the incentive to abscond for the family and with the children. And obviously, for the children, the benefit is that they do not feel imprisoned because they feel in a situation which is closer to a normal context than it would be. Obviously, nobody takes away the fact they know they are going to have to leave, but it is within the nature of the things. Another alternative to detention, which is very effective, is foster family. It's not always available because for the unaccompanied child, basically, normally the danger of them absconding is usually associated with not being properly taken care of. It's not always the case. I mean, sometimes, for example, in Italy, many of the unaccompanied children who arrive to Italy do not stay in Italy, but this is not because the system is not receiving them well or not sufficient resources are being, or attention or affection, if you like, is being devoted to this. Sometimes it's a pure reality. I mean, the children want to be reunited with communities in a northern member state. It's their migratory project, either family members or because they want to join simply their community. When it is about family members, in theory, there should be legal ways, at least if those family members are legally residing in the countries in the north. But under the current rules of Dublin, for the asylum applicants, as we know, family reunification procedures sometimes are not taking place very quickly. There was a study which you can find very easily online, done by Praxis and Safe Passage, which is a UK organization specialized in family reunification. And it was done on family reunification of unaccompanied minors from Greece towards other European countries. And they are showing that basically on average, the duration of the procedure was about 18 months. And this is not taking into account the time prior to the child having even been identified and actually the procedure being launched. We have heard, I think it was Laurent who mentioned the example of the child who was off the radar in Greece, for months, and it was the case of the children who are outside of the Moria camp in Lesbos or on many of the Greek islands, because the capacity was full inside the camp. And they were sitting outside and they were not even registered or identified. So for months and months, they have been there. Now they are no longer there. This is the good news. All of them have been transferred to the mainland, and in theory, all of them have already been identified and registered. On the side of the proposals, the new pact contains this time, yes, there are some novelties that help family reunification. One of them is expanding the definition of the family members with whom you can be reunited. So it will be in the future, hopefully possible to be reunited with siblings, so brothers, sisters in other member states. So far it was not legally possible. Then there is a provision on rendering more flexible the deadlines for the processing of the application for family reunification. More flexible, not with the intention to prolong it forever, but more flexible in the intention that applications shouldn't be rejected because the country where the child is hasn't provided the proof of family link within the foreseen deadline. So these kind of things, which were used as a ground for turning the file down. And then there are clearer rules about the kind of evidence that needs to be provided about family links. At present, there are many obstacles in that account because member states have different requirements when it comes to proving who is family member. And some of them have even taken it a little bit a notch too far. I mean, there is one particular member state where many people want to go. I'm not going to mention it, but who was asking, apart from proof in writing. So let's take, for example, a child has a photocopy of a birth certificate. So that would not be considered sufficient. It would be complemented by a request for DNA testing. And this we consider to be a little bit too much. So yeah, I mean, the idea is to ask what is reasonable in terms of, obviously member states have different requirements and that is understood, but you do not always have to arrive to the level of documents plus DNA testing together.
Yeah.
Yeah.
Thank you for all these clarification. It's very interesting, but we see how complex it is and how all the dimension of the of this issue is very difficult to combine and to try, and especially if we really want to put the child in the center and look at him as a child. In the chat, we still have two different, it's not question, just mentioning some resources. Marek, you may have seen that Winnie Bunny from the Red Cross is saying that the Red Cross is conducting some tryout between the General Commissariat and minors of the guardians at the Red Cross. So there is some result that can be accessible through Anya de Wilde. And Bram from the platform Minor in Exile is also giving some references concerning some tools from the ASAO, interviewing children, training provided by Solentra, and so on. So these are all resources that we can use and refer to. And Mike is also sharing other resources, and we will add them in the report of the meeting. So thank you for this very interesting and intense discussion. So now we continue on the presentation of the outcomes of the project. So you already heard Laurent presenting the European report in his nice presentation. And now I propose to Vanessa to present the toolkit, which is also one important tool that was produced during this project. So Vanessa works for the World Service Foundation inside DCI, Defense for Children International. And this foundation is aiming at providing technical assistance and capacity building to the movement, DCI movement. And in the past few years, she has been working in addressing gaps in the protection of child migrants. And most recently, she has been appointed also to join the Child Friendly Justice in Action project as coordinator together with Laurent. So thank you very much, Vanessa, to be with us now, and I give you the floor.
Thank you, Benoit, and thanks everyone every one of our speakers, but also participants. It's really great to see so many are still with us, because we know it's quite a long session, but I think that shows the interest in the topic. So I'm just going to share my screen with you. I'm going to present the toolkit, which came out of the Child Friendly Justice in Action project. There we go. So just to put it again, to remind everyone of the context of the background and context of the project, which Laurent explained a little bit earlier, but the project really included desk-based research, but also interviews with stakeholders, so professionals in contact with children in the context of those migration-related administrative procedures. And these included lawyers, protection officers, guardians, representatives from civil society, etc. So I really want to say that what you're going to see now, this toolkit, the starting point was very much what we heard through these interviews, the feedback that we collected from professionals. So we interviewed a total of 248 professionals across the 7 countries where the project was implemented. And what we found was that there is clearly an interest, an appetite to be better equipped to be able to mainstream, even if they might not call it the child-friendly justice guidelines, they might call it something else, but there's this interest and appetite to be able to treat and support children differently through this complex procedure. So we saw there was an appetite, but also that, and sometimes an interest in receiving more training, sometimes some professionals taking it on their own initiative to seek trainings or to attend webinars or to consult jurisprudence from other countries, for example. So there's clearly an interest, but it's not always so clear for them apparently where to find adequate resources. And so we very much try to take that feedback on board, and thought that there are, as we've heard from different speakers, Regina mentioned it, we heard from Isabella, we heard about the training that some protection officers receive as part of interviewing children in Belgium. There's quite a lot of resources, tools, toolkit, etc., that already exist. So we really didn't want to pretend reinventing the wheel and maybe producing yet another toolkit or checklist or tutorial webinar that might sort of be added to the long list of what already exists, but maybe without you know, without necessarily adding value, or that it would soon be forgotten because there's so many toolkits and webinars that come out quite often. So initially we started sort of mapping to understand what the state of affairs was, and our early sort of mapping found 20 tools, at least 20 tools, and different checklists and so on. Of course, some of the key documents and resources that we use, I'm not going to repeat them all, but of course the ESO guidelines on procedures involving children, of course the Council of Europe child-friendly justice guidelines, which are very much a cornerstone of our project, but then the additional, some of the additional guidance they've developed over the year, like how to convey child-friendly information to child-friendly information to child migrants. And then, of course, we were faced with the challenge to try and develop a framework or a tool that would have relevance to the different groups of professionals that we were targeting. We know that the role of that, we can really see there is a role of different categories of professionals that really come in contact with children along their journey, along the procedure. And also, of course, we were working across 7 countries. So that was the challenge. And we decided to, we were inspired by a couple of other projects we found, which similarly tried to develop sort of a common framework across 7 countries, across several countries like us, which eventually made us inform the methodology we chose for the toolkit, and which I'm going to present or give you a taste of now. So essentially what we decided to do, using very much the child-friendly justice guidelines as the backdrop of this toolkit, we thought that we would try and really use it as a register, as a depository for all or as many as possible tools and resources, guidance that already exists. So just a word of caution and warning that, of course, by the very nature of it and what we know about the different tools, and sometimes that multiply, the toolkit is not, we're not pretending it to be exhaustive. We're hoping it's comprehensive. But we very much see it as work in progress and as a living document that we can keep updating with interesting resources and tools. So with that in mind, sort of using it or starting to think a little bit of developing some sort of a library or user-friendly as possible for the professionals that we are targeting, we decided to identify a number of success factors. So these are in the toolkit enabling factors, which make it more likely that the conditions are in place for professionals to effectively deliver child-friendly justice, child-friendly services in their day-to-day work with children. And then for each success factor, we identify a series of guiding questions. So these guiding questions are very much sort of self-reflection questions to encourage professionals to ask themselves, how does that relate to my work? Have I thought about this? Have I considered this aspect? So it's really to try and be as supportive as possible, not too critical. We know that they operate in a very complex legal framework very often, also sometimes in difficult conditions on the front line. We'll hear from our colleagues in Greece and Italy in a bit. So really wanted to try and simplify as much as possible, whilst also identifying some of the blind spots that might exist. So using those guiding questions, we then highlight what inspiring practices, and we chose to distinguish between 3 categories. First, inspiring ideas suggested by professionals. So these might not be toolkits, guidance, webinar, etc. But we feel like there's a lot of maybe informal institutional knowledge. Of course, those professionals at the end of the day, they're the ones on the front line working with children. And we see that sometimes they've been very innovative and just taken initiative to just make small adjustments in their work. And I think that's worth compiling and collecting in this toolkit. Second, we've also highlighted legal innovation, so best practices. Certain countries have, for example, in Italy, we have a very quite progressive and comprehensive legislation on the role of guardianship, of guardians, sorry. And then finally, more practical resources like toolkits and webinars or checklists and so on. So I'll just show you two examples to try and illustrate this a bit better. So for example, sorry, I'm just going back for a second, just to give you some numbers. So far, we have identified 14 success factors. We have 50 guiding questions for professionals, and we have 36 IDs, tools, resources listed in the toolkit. So if I show you the example here, for example, of something that we feel is maybe it's very obvious, but key to making sure professionals are mainstreaming child-friendly justice is, of course, whether they've received appropriate information or training themselves. So here, this is the success factors is training and information. We just provide a small definition here, what we mean. And you can see here on the left, we provide a couple of guiding questions. These questions really encourage them to maybe find resources in their lived experience or own expertise, but also to maybe give them that little encouragement or nudge to maybe inquire within their institution or their organization whether there might be resource, whether their organization might be willing to invest in training, or at least challenge why is there no training specifically on children, even though that's part of my work, for example. So in this case, we highlighted a webinar, an online training module from the Council of Europe, and we also actually is something that came up earlier in this very webinar, the good practice found at the Commission General in Belgium regarding the training that protection officers receive. And then the second example, I thought I'd focus on the right to information, the fact that there are or not there exist child-friendly, child-specific information materials, or I'm sorry, I have some notifications, available for children, but then of course for them to reach children, often as we've seen, professionals and guardians, for example, have a really important role. So do they know where to find the information? Do they know how to convey it to children? So again, we identify a series of guiding questions and corresponding tools or ideas. So these are two examples. We will, of course, circulate the full complete version of the toolkit as it currently stands after this webinar. In terms of the next steps, I want to say that, as I said, we very much see it as a living document. Please get in touch if you're interested in, if you're spotting any resource that would be worth including that is not already there. At the moment, the document exists in hard copy and soft copy, but we're hoping that maybe further down the line, we could have something even more interactive, maybe hosted online, which could be even more user-friendly, and that would be easy to update regularly. So I've included the email address here. The tool will be also available to download on the website of the Child-Friendly Justice European Network. And I think that's all. Thank you very much.
So thank you, Vanessa. I hope that everyone had some feeling about the content of this practical tool and hopefully sees where is the added value, because as she mentioned, the difficulty is that there is already so much out there, and we really wanted to avoid duplication or to just add one other tool on the long list of existing tools. So now that we have this view on the practical tool, we have a new panel of presentation on the child-friendly approaches and practice for refugee and migrant children. And first of all, we will listen to Stephanie Rapp, with us from the Netherlands. She's an assistant professor in children's rights at the Department of Child Law in Leiden. And her academic interest lies in the field of effective participation of children in diverse judicial procedures and settings, such as juvenile justice, child care and protection, but also in asylum and procedure and in school. So very broadly child participation. And so she has a very broad experience in different children's rights issues, and is someone with whom we work very closely and often in different projects. So it's a pleasure to have Stephanie with us today. So you are welcome and you have the floor.
Thank you for your kind introduction, Benoit. And also thank you for inviting me to this event. I will start sharing my screen. Yeah, today I will talk about my research that I've been doing for the past 3 years on children that apply for asylum in the Netherlands specifically. And I will also touch upon a project that I was involved in and that was commissioned by the Council of Europe, in which we made a compilation of promising practices in the field of child-friendly justice practices for children in migration. So I will share some examples of that compilation as well. First to recap a little bit, when we look at the guidelines on child-friendly justice, participation is one of the main elements. To make procedures child-friendly, it means that children should be able to participate in these legal proceedings, and it also counts for children in migration proceedings. And of course, the right to be heard and the right to information are core elements of that. Specifically for children who are involved in asylum procedures, it is important that special attention is paid to their views and also the reasons for applying for asylum. And also that should be done separately from their parents when they are accompanied, for example. And that is specifically what the CRC committee also highlights. The right to information is very critical in that regard, because information allows children to form their views and opinions, and also to form a view of what is expected from them during the proceedings. So that is very important. So explanation should be given to children, also about the consequences of the procedure and what the possible outcomes could be. And of course, it is also very important to inform children about the outcome of the procedure. Also, when the outcome is not a preferred outcome for the child, then it's even more important to explain the reasons of, for example, rejection of an asylum claim. The European Court of Human Rights also made a connection between right to information and having access to justice and having access to available remedies also. So they stressed also that information is necessary to be able to access justice, specifically also in cases of children who were in migration detention, and they were given information in a language that they could not understand. So they were also not able to challenge their detention. In my research, I also look at why it is important to involve children, and not only as a human right or a children's right, but also more from a sociological perspective. And there has been quite some research conducted on children involved in judicial proceedings and how they experience that in child protection proceedings, for example, or children involved in separation or divorce or in conflict with the law. And mostly in all of these studies, children say that they find it very important to be heard by the person that's taking the decision in their case. So that the judge really has seen the child and has heard his or her views, and not from another third party, for example. And also, this research also very clearly shows that when children are not listened to, yeah, they feel frustrated and yeah, losing control over their case, and also yeah, not feeling autonomous in their case. So it can really help also in their mental state and how they have perceived the proceedings. It also helps in their understanding of the outcome of the procedures. If they are heard, they also have a more positive view on how the proceedings went, and also better understand and accept the outcome of the proceeding. Yeah, all over we hear also during this afternoon that children lack proper information, so that there should be given more information to children, and that specifically also relates to children who are involved in migration proceedings. They arrive in a strange country where they don't know the language, they are involved in highly complex asylum application procedures. And giving them information on their rights and on the procedure and how it will go is very important in that regard, and is yeah, lacking in many countries. Specifically also for accompanied children, this is important because in many instances it is assumed that parents will inform their children because they are the applicants in the procedure. They will have a lawyer and they will receive information, and children are, yeah, quite invisible in these procedures. Then I would like to touch upon some preliminary outcomes of my research. I've also joined forces with DCI the Netherlands in doing some of the interviews also with young people, which were also used in the country report in this project. And next to that, I've also interviewed about 42 professionals working in the asylum procedure in the Netherlands, like lawyers, guardians, but also immigration officers who actually conduct the interviews with children. And I, up to now, I spoke to 7 young people, accompanied and unaccompanied, and that research is still ongoing. Yeah, I also was able to do some observations of interviews. I will not touch upon that in this presentation because it will be too much. But it is very interesting and was also very valuable to my research that I was able to see some audiovisual recordings of interviews of children below the age of 12. When looking at my research outcomes, I think it's very important to make this distinction between unaccompanied and accompanied children, because there's yeah, a very different practice with regard to these two groups of children. And when looking at information, most people who work in the procedure say that there's quite a lot of information available for children, and there are quite a number of different organizations involved in providing information, like guardians, lawyers, but also in the Netherlands, the Dutch Council for Refugees. Yeah, but the overall impression from my research is that the way information is given and yeah, the depth of the information really depends on the professional and his or her involvement with the young person. With regard to accompanied children, as I said, they largely depend on their parents. The Dutch Council for Refugees has set up several projects to reach these children in the asylum seeking centers. But they are not able to reach all children with the information sessions that they organize. Regarding participation of children and specifically relating to their asylum interview, it is important to highlight, and I think that also showed very much from what Marijke also was talking about, that it is a very specific purpose that this hearing has. It has the purpose of, yeah, assessing the asylum claim that someone makes. And the immigration officials also state that they have to know about yeah, the reasons for applying for asylum, and that they have to engage in truth finding in that regard. And therefore, on the other hand, for example, lawyers and guardians state that, yeah, it's not really an instance in which children can really meaningfully participate because they have just to answer certain detailed questions on their application. And they're not really open to tell their own story in that regard. when talking to children, they also perceive the interview as something that is a given. They are nervous about it. And also specifically, I think for accompanied children, it can be very burdensome because they feel large responsibility towards their parents and their family as well, because they have to tell the same story. And they don't know if they're doing the right thing when telling their story. So that can be very confronting. The immigration authorities also explain that confronting children with inconsistencies or with certain details is not something that they really stress on, but it can happen. For example, when children say things differently from their parents, they can be confronted with that. And that can be very difficult for children to go through. When looking at the compilation I worked on, that was commissioned by the Secretary General on Migration and Refugees of the Council of Europe. And it involved a compilation of practices that took place in Europe. It was published last year, so some of these practices may not be operational anymore, but hopefully they still are. It dealt with different phases of the migration process. We received, it was an open call for states and organizations to send in their practices, and we received around 160 submissions, of which we made a selection. And around 40 countries are represented in this booklet. And you can also find it online through the link on the slide. And I would like to highlight some of those practices. First, we received a booklet from France, which was developed by the Grenoble-Alpes University, which is a non-linguistic booklet, which means it's all in cartoons and in drawings. And it is made to really help frontline workers to communicate with unaccompanied children who arrive in France. It is to give information to children on the one hand, to better understand the reception conditions and the procedure that they will go through. And on the other hand, it also helps professionals to learn more about the young person, on where they are from, which nationality they have, what language they speak, for example, to make this communication a little bit easier. Another practice that I would like to highlight is from the Netherlands. And that relates to accompanied children. The Dutch Council for Refugees has started a project to identify child-specific motives for seeking asylum for accompanied children, which means that when identifying these specific motives, it would be possible for these children maybe to file their own asylum claim separate from their parents. Normally, these children go along with the claim of their parents. They're only heard from the age of 15. By doing this sort of preliminary assessment by the Dutch Council for Refugees, they would like to see if there might be possibilities of involving the young person earlier, and also having a separate interview, for example. And they will also inform the lawyer, for example. They have made child-friendly materials, and also they have made a checklist to see what kind of child-specific motives for seeking asylum could be there that can lead to an asylum application. The final practice that I would like to highlight is from Poland, which involves the interviewing of unaccompanied minors by specially trained caseworkers. And important here is that it was highlighted that children do not have to travel to a place or a office of an immigration authority, but they are interviewed at the place where they're staying. And the other important thing is that a psychologist is involved in the interview. And the psychologist is there to observe the child and to see if there are any stress or trauma appearing, and also to assess if there are any psychological needs that need to be addressed later on after the interview has taken place, which I think is very important to assess the mental health of the child also during the interview by a specialized professional. To conclude, this compilation of practices that we gathered really showed that because we also did a legal analysis of all the standards and guidelines that are out there, and there are many standards and also many good intentions, but there's still a gap between all these documents and the reality of refugee migrants, children, and the assistance that they receive in the procedure. So as I said, there's a large number of practices and a wide variety of practices in Europe, but it also showed that a lot of these practices depend on external funding, for example, that they are small scale and sometimes only one-off and very localized. And it showed really that there need to be more sustainable ways in assisting children in the asylum procedure and making it more child-friendly for them. And that means that, continued effort should be made to invest in this cause. And I'm very happy with the toolkit as well. And I think this can only lead to better integration of practices, and hopefully countries can learn from each other as well. Thank you so much. And I look forward to the Q&A.
Thank you, Stephanie. Very interesting, and it's linked to what has been said before, and your research highlights a lot of the conclusion that different projects have been also highlighting. So it's very important, and also this gap between the theory and the practice, and how to implement concretely those principles. Once again, they appear very, very clearly. In the chat, I can see that Marine is proposing to transform this tool in an app that could be interesting. And I know that there are also some apps that have been created in different fields, also to give information to young migrants and in the language that they know. So that's probably a good idea that we can think of in the next phase of the project. So now we will enter into two presentations from partners of the project that will highlight the concrete action that organization working in the field can do, and how actor can act in trying to improve children's rights concretely. First of all, we will listen to an experience in Italy, and we will have the chance to have with us two Italian colleagues. One is Caterina Parodi, who works for DCI Italy and is Child Safeguarding and Protection Officer. Hello, Caterina. And you will speak together with Mauricio Fasque, who is a voluntary guardian working in Genova in Italy. So you have also this direct experience with children, and you are facing all those questions and difficulties that we have been talking about since the beginning of this conference. So Caterina and Maurizio, I leave you the floor and I let you organize your dialogue.
Thank you, Benoit. Thank you to all the speakers, and thanks to all the participants gathered today to promote child-friendly justice. As Isabella referred before, Law 47/2017 is key in the Italian legal migration framework. This groundbreaking law ensures inter alia an holistic age assessment, the social file, and formally recognizes the figure of voluntary guardians for unaccompanied minors. The voluntary guardian is a citizen who voluntarily and free of charge assumes a role of legal representation and monitoring of the best interests of the child. It is an expression of civil commitment in Italy. Being independent actor from the reception system, he is there to act as a gatekeeper of the rights of the child, free of any conflict of interests. Despite the many difficulties, after 3 years of implementation and observation of this law provision, it is demonstrated that this model for volunteer guardianship represents a powerful tool of protection and representation for unaccompanied minors. Defense for Children Italy today welcomes Maurizio Fasce, a voluntary guardian from Genova, and thanks him very much for his participation. Maurizio, I give you the floor. Thank you.
Thank you, Caterina, and thank you, everybody. Good afternoon to everybody. Thanks for the invitation to this roundtable. So just to introduce myself quickly, as has been said, I live in Genoa, that is a city in northwest Italy. Genoa is sadly known as the town of the falling bridges. I say it because bridge will come again in my speech. So my name is Maurizio, I am 60 years old, and I'm one of the Italian volunteer guardian we're talking about. I am an HR manager in a retail company. I say this because that means that I used to be busy, very, very busy. And I'm busy also because I do other voluntary activities as well. For instance, these last 5 years, I'm with the inmates in the town prisons. What else can I say to introduce myself? Well, I've got a daughter, she's 30 years old, a social worker, and I've got a mate who is a prison educator. I can't say her age, but I live by myself. I underline these two items of my biography, that I'm busy and I'm living alone, because I thought there could be problems to be a guardian, but as I say, they aren't. How I became a guardian. Until March 2019, I even knew nothing about the presence in Italy of unaccompanied foreign minors. I've always been quite concerned with the migrants matters, because I meet lots of them in prison. And because I worry about the political drifting that my country in the last years is having. But when I thought of foreign minors, my mind went always to stereotyped images of undernourished children in their country. But in March, a friend of mine who was beginning to be a guardian told me about his experience. His tale was strong. I realized that minors in needs exist also in my country, and especially I realized that they could help. So I offered my willing to do it, and now I can say that I've chosen it because to be a guardian can help. September 2019, I had a 2 days training held by Defense for Children Italy. The focus of the training was the central issue of a guardian being a bridge, here comes the bridge, between the child and all his needs, that from our point of view, needs constitute his rights, need of health, need of education, need of protection, need of relationships. And our role, the role of the guardian, is acts in connection with all actors, the shelter, the authorities, the civil society, to permit the child to satisfy these needs, these rights of his. Training has been intensive and engaging. A long weekend with the 20s of other interesting people, learning about rights, procedures, and meeting elder guardians already experienced it. As I said initially, I was afraid not to be able to face the task because I live alone and because I have a few time. And I was afraid I wouldn't reach the competence asked to be a good guardian. But later I found out I was wrong twice. Because what a minor needs is not a family, because he's supposed to have already one in his country and he didn't afford the trip to find another one. And no competence is needed to help him, apart from the competence of listening and taking care of the rights, the needs of the person. This is quite important. A guardian is not asked to be specialist or professional, no more than a parent is. Specialists are already at the disposal. We have lawyer, educators, social workers, doctors, teachers, policemen when it's needed. While a guardian is just asked to be the child's spokesman with all of them, always in the child's best interest. So the training, then a few months later, I experienced how true and how important is all this that happened during the guardianship of an Albanian boy. I'll call him Tom, it's a fantasy name. I took an oath on the juvenile court where I was assigned the guardianship of Tom on November 2019. And since then, I had to report periodically the physical and moral condition to the judge of the court. I have been Tom's guardian until his major age, that was on last July 2020. So 9 months, more or less, in which Tom had to face many important problems. First of all, he had to learn as soon as possible a new, for him, difficult language, because he didn't even know a single word in Italian when he came. Then he had a bad accident. He nearly died for a bad fall with severe harms on his head, so that he spent, for instance, New Year and many weeks in hospital. Then he had bad families problems, as Albanian minors often have, and also bureaucratic problems with documents, typical Italian style problems, and behavior problems that wouldn't be problems for any other Italian boys, but that can be huge problems for any migrant. Finally, he had the problem of the problem, the bigger one, that is to get him into the age of majority without having reached yet his goals, because the long hospitalization first, because the coronavirus lockdown then, he couldn't forget. Among all these problems, the presence of a guardian helped a lot. I did nothing directly. All the jobs have been done by professionals, teachers, medicians, lawyers, psychologists. Yes, also some psychologists and psychologists have. But my presence kept all them together. And my job was to keep Tom always concerned about where he was, what he could or what he couldn't have or do, who were the persons he was meeting, etc. I had to keep him acquainted of the possibilities to satisfy his needs. I found out, observing and comparing the situation of other children, that the sole presence of a guardian makes the difference. So that when authorities realize that nearby the name of the minor in any list, there is also the name of his own guardian, suddenly the mood changes, the attention grows. The child becomes something more to be treated. That's horrible, because it means that guardianless children are less a citizen than the one with the guardian, of course. But at the same time shows the importance of this figure. For the chronicle, Tom obtained a very long period of administrative continuation. That means that now he is allowed to remain in Italy until the age of 21 to find a job and accommodation. That important goal has been reached thanks to a very good legal relation that the lawyers of the Defense for Children and the lawyers of the shelter wrote. But surely also because it was a signet and presented and supported by an Italian guardian. And by the way, always for the chronicle, I told him Benoit. So a guardian, has been said, is a volunteer, and as I said before, is not professional in any of the matter in which can be involved, apart from the main one, is to represent the best interest of his pupil, like a parent for his sons. In my opinion, these two characteristics, volunteerness and the specialization, are very important for the guardianship's aims. As Caterina said, being unpaid allows a guardian to be completely free and autonomous from any other force. A part, of course, of the best interest of his pupil. So, I mean, a free guardian cannot be conditional. And being unspecialized is Thanks to the unspecialized, guardian is safe from the process. Therefore, he can put all his concentration just on the result. Summing up and to conclude, in Italy, guardian is a common man or a common woman that gives his time for free in order to take care of a minor in his best interest, making any effort to help him to reach the goals that brought him in our country, preserving him from the many problems that a lonely child can meet, being a bridge, as I said, between him and his needs, and between him and the person that can help him in realizing his goals. Thanks for the attention.
Thank you very much for this very lively presentation and concrete example of a situation that you are facing, and yeah, one way of meeting the rights of the child in migration. So thank you for that. Before coming to a question and answer, so don't forget to ask your question by writing in the question answer chat. I will finally give the floor to our last speaker of the day, Iris Papa, who works for DCI Greece on guardianship, and she is involved in one of the projects DCI Greece is running, which is a legal help desk offering protection, legal and social counseling for children in migration. And she's very much specialized in the, of course, children's rights, but in this specific sector of children in migration. And we know how much Greece is facing, maybe in the same way as Italy, but maybe even more difficulties in trying to respect and fulfill children's rights in migration, and not because of only because of the situation in Greece, but also because of the lack of solidarity of the rest of Europe. And this is probably something that I want to stress. But it's a pleasure to give you the floor, Iris. Thank you for being with us.
Thank you very much, Benoit. Thank you all for being here today. So let me first share my presentation that I have prepared so as to be able to have a look. One second. I think now okay, perfect. So actually, in Greece, the research was focused on unaccompanied minors in the context of asylum proceedings. The aim of the research was to examine actually whether or not, and in what extent, the principles are being implemented during the whole asylum procedure, and whether the administrative asylum system in Greece is adapted actually to the specific needs of children and their vulnerability. Our research basically tried to answer questions like, are the child-friendly principles being implemented and respected by the national asylum authorities? Is the principle of children's right to participation respected? Have children adequate legal support and information? So from a methodological point of view, actually we completed here in Greece a desk research regarding the national legislation and the practices, and we also conducted qualitative interviews with the professionals working in the asylum authorities and in the field in general. Of course, key role in our research had the voice of children. Children answered the questionnaires. Also, they had the chance to participate in some theatrical acts that we conducted, representing the different stages of the asylum procedure. And they also had the chance to draw how they felt and how they are feeling while during actually these asylum proceedings. Of course, the research is also capturing our first-hand experience on the field. Well, the first and obstacle actually unaccompanied children face upon arrival in Greece actually is the complicated legal framework that they must navigate in order to seek age-appropriate protection without having actually the support. They are totally alone. While under Greek law, state authorities are obliged to respect children's rights and the child-friendly principles, this is not implementing in practice. In fact, in Greece, there is not an effective implementation of the child-friendly principles and guidelines of the Council of Europe because of the various and very serious systemic problems of the reception and asylum procedure and the dysfunction of the relevant authorities. These structural actually existing reception deficiencies on the Greek islands or the borders of Evros have a domino effect on the situation of the refugee children. As you may be aware of, in Greece there are two different asylum proceedings. Another procedure is followed in the mainland, in borders, and another procedure is followed on the islands that they are subject to the European Union-Turkey deal. On a daily basis here in Greece, children are crossing the country, for example, through the borders of Evros without being registered by the authorities at all. And at the same time, we have children that are leaving from the islands before completing their registration because of the inhuman and dangerous conditions that exist there. Sorry, I just realized that my presentation was stuck. So due to the serious systemic problems of the reception and asylum procedure, the dysfunction of the relevant authorities, the lack of guardianship, the lack of information, the lack of legal support, the rights of unaccompanied minors fail into the cracks, while most importantly, leave children totally alone, totally unprotected, and exposed to serious risks such as the sexual exploitation, trafficking, and abuse. Some of the major deficiencies which prove actually the non-respect of the principles could be summarized in the following ones. As you can see, lack of appropriate accommodation for children. Many children, as we said, are not registered by the authorities and are homeless. Consequently, they are not aware of their rights to legal support, to apply for asylum, to apply for family reunification. There are many difficulties in booking an appointment so as to apply for international protection, and actually requires a pre-registration number, which is quite problematic because, as we said, not all of the children are registered upon arrival. Lack of information on international protection procedures and deadlines. Lack of guardianship, since the law on guardianship is not implemented yet in practice. There is no transparent procedure of the age assessment. We have, of course, detention, the protective custody, and a lack of administrative personnel. Today, due to the limited time that I have, I will try to focus my talk on the reception procedures that actually determine children's condition in Greece and that impede children to access effectively the asylum proceedings, but I will also refer to the deficiencies that exist during children's participation in the asylum proceedings. I will begin with mainland and the borders of Evros. Children actually who enter Greece through the borders of Evros are subject to the reception and identification procedures at the RIK of Phylaki, which is in North Greece. Unaccompanied minors are transferred to the RIK where they remain restricted. Because of the lack of shelters, the majority of the children may stay there under the scheme of protective custody for a long time that may exceed 1 or 2 months because there is no accommodation. Our research also actually revealed several incidents of wrong age assessment. We had a boy actually from Afghanistan who entered Greece through the borders of Evros. And during the pre-registration, the police officer, without prior proceeding to a proper age assessment, he just wrote next to the date of birth of the child the age 37 years old. At that moment, the boy was only 17 years old. Also, our research revealed that the majority of children who crossed the borders of Evros were not registered by the authorities at all. Basically, all children that participated in our research shared with us that no one stopped them while crossing the borders, and that with the help of the smugglers and the refugees made their way to Athens. All of them shared that they were feeling totally lost, totally alone, without knowing how to proceed, how to apply for family reunification, how to apply for international protection, and how to find accommodation. As Ahmed told us, when I arrived in Greece, I had no one, sorry, just I cannot, to be able to read the quote. When I arrived in Greece, I had no one to help me. I arrived in Athens and I did not know what to do. I met some people, they told me will help me to go to my brother in Sweden, but they just took my money and stopped me. I thought I will die alone. At the same time, children receive inadequate first reception, identification, and registration services while residing for a very long period of time in the reception centers in the islands of Eastern Aegean Sea near Turkey. The system actually failed to implement assessment that reflects children's best interest, age-appropriate information, and legal representation. This, upon arrival actually on the Greek island, refugees, including unaccompanied minors, are taken to the reception and identification centers where the pre-registration takes place. Children at this stage do not receive any information at all about the procedure and about their rights, nor legal support. This first instance, of course, procedure are of great importance since they determine the future and the child staying in Greece, his access to accommodation and to services available for them. Worth mentioning, of course, that due to the lack of staff capacity, unaccompanied minors are only getting pre-registered without being able to proceed with a full registration at the asylum office immediately, which of course, as you can imagine, has a negative impact on their case. In such context, and in absence of an effective guardianship network, unaccompanied children endure long waits and uncertainty, while at the same time their applications are being processed. An indicative example of this is Omar's case, who wanted actually to apply for family reunification and whose case was rejected several times by German authorities because Germany counts the 3-month deadline from the moment of arrival and not from the moment of registration, where actually the child can apply for family reunification. As Omar told us, when I arrived in Greece, I had no one to inform me about anything. I was just following orders. I just said I have a sister in Germany. Can I go there? Then they informed me that I can apply for family reunification only during my registration at the minor's office. I do not remember exactly when was the last time I slept without being afraid of my life. I thought leaving Afghanistan would bring me peace, but I was wrong. Every night there are fights, and at any given moment someone can enter the tent. Once a man tried to rape me. I managed to avoid him, but I don't think I will be lucky next time. Omar actually is still trying to understand if he made a mistake along the way. Child-friendly guidelines are not seen to be respected and implemented, nor during the asylum procedures. Regarding registration, as above mentioned, hundreds of children made their way to Athens through the borders of Evros or through the islands without being registered. The option given to them is to try to book an appointment for registration so as to apply for international protection, filling a very complicated form at the site of the Greek Ministry of Migration that requires, however, the pre-registration number. It might take months, actually, until the asylum office will book the appointment. And this actually places children run the risk in the meantime to be arrested by the police and to be detained because they do not have a legal document so as to prove that they are asylum seekers. Professionals that participated in our research, in their vast majority, as you can see, agreed that the principle of the best interest of the child is not always granted for unaccompanied children. On the contrary, children's rights are being violated at every step of the process. As they pointed out, there is not a specific framework and guidelines regarding how administrative officers as well as individuals working in child-related positions should deal with refugees in a child-friendly way. The lack of administrative position is another very serious issue here in Greece. One employee, as a result, is forced to deal with multiple cases, and this factor makes it almost impossible to cover all the needs. The situation is chaotic, as a caseworker says. Finally, all of the professionals agree that there is an urgent need of trainings. Children, on the other hand, outline the loneliness and invisibility they experience along the process, as well as their urge and anxiety to find proper guidance and support. They highlighted the difficulty navigating through the complex asylum system in Greece and the neglect they experienced as a result of the great deficiencies. First and most important, all of them were not entirely sure about the reasons they had to go through these procedures. The majority of the children were not really happy with the way asylum office workers treated them. They wish they were friendlier, more patient with them, and also more willing actually to explain the procedures, but most importantly, the meaning behind them. Some of them were not informed about the rights to apply for family reunification, but even if they knew about that right already, there was no proper guidance for the exact procedure. All children would also wish a more welcoming place during their visit to the authorities, so they would not be scared. The queues are very long and they have to wait for more than 3 hours before entering the asylum office. As they told us, what they would like to see in the whole asylum process is, of course, easier access to information, faster procedures, friendlier environments, having access to a safe shelter, and also someone they can refer to and receive support from. Here you can have a look on what children actually shared with us. Nobody informed me about anything. I was homeless and registered for months. When I arrived in Greece, I was an invisible person. Some children are alone. I believe that it could be better if upon arrival to the country we had a social worker or a lawyer or a person that would support us during the whole process. I don't know how to explain it, but to be honest, nobody asked from the authorities about what I need and what I prefer. Refugee children, I believe, they just are on the hands of other people. Authorities decide where to transfer you. Authorities decide about the date of interview. They just even change the date without informing you. Registration process, but also the asylum interview is like interrogation. I had to wait on the line, even if I had an appointment, more than 3 hours. At the asylum office, they only had an Urdu interpreter. I speak Dari. When I mentioned I don't completely understand him, they told me he was the only one available, and that Dari and Urdu are almost the same. So you can see that children during the whole process are totally alone, and what they most want is to have actually a person to guide them and to offer them the support they need. It goes without saying, actually, that there is an urgent need of creating an asylum administrative system adapted to children's needs and rights so as to guarantee their fair access to the asylum proceedings. The right to information, the right to be informed, is the key factor for the effective participation of children to the asylum and administrative proceedings. As aforementioned, first instance procedures are of great importance as they determine actually the future of the minor stay in Greece. Today, of course, there is a lot of information on the internet, but it does not guarantee children's understanding of the procedure. For this reason, we strongly believe that information sessions should take place from the very beginning of the asylum procedure by specialized personnel, so as to receive information in a child-friendly way adapted to the needs and aids by trained professionals. Guardians, of course, should have a main role in ensuring children's protection, care, and rehabilitation, and they must ensure there is easy access to information, the asylum procedures, and justice. For this reason, it is important, finally, the loan guardianship to start being implemented so as a sufficient number of well-trained guardians to be appointed for every child upon their arrival to the Greek territory. Adequate, of course, legal representation and support is a requirement in defending effectively children's rights and ensuring that all asylum procedures are in line with child-friendly principles. Therefore, it must be secured that all children on the move have the legal support they are entitled to. As above mentioned, non-state-free legal support is provided under law on first degree. That means that children that are not supported by an NGO are totally alone during their asylum hearing. The hearing actually that will determine their future. For this reason, it is necessary children to receive legal support from the very first contact with the asylum authorities, regardless the presence of the guardian. The guardian, of course, should be the central actor responsible in linking the child with a lawyer that will support them with their asylum claim. State-funded legal aid for first instance procedures and an NGO network specialized in children's and refugee law is proposed. In order now to ensure child participation and the right to be heard in judicial proceedings in a manner that respects the right and the child-friendly principles, it is important to provide a safe and friendly environment, actually, that respect the right to privacy and special needs. Also, to create a separate...
May I ask you to conclude in
yes, 1 minute. Yeah,
1
of
minute,
course. Yeah. Sorry. And of course, lastly, but most importantly, to guarantee children's access to third remedies. The principle, of course, of the best interest of the child should be a key element in the refugee child protection. The states must guarantee its effective implementation in all matters involving or affecting children. It is important the determination of the best interest of the child to be an ongoing procedure that will start inside the reception facilities along the pre-registration procedure and will include every child. As it can be concluded, because I don't have much more time, the way you can see that the way the administrative asylum procedures are implementing in Greece harm actually children and deepen their trauma. In Greece, because of all these deficiencies in the whole asylum procedure, children actually experience an additional wave of persecutory harm defined by serious breaches of their rights. For this reason, it is crucial along the whole asylum process, the right of recovery and rehabilitation to be implemented in the context of the restorative justice. Greece and Europe in general, we strongly believe that they should adjust the whole asylum procedure to children's needs by forming a restorative asylum justice system that will focus on the rehabilitation of asylum-seeking children, aiming to recover actually their existing trauma, which, as aforementioned, gets deepened due to these structural human rights violations. Thank you very much.
Thank you, Iris, and we see how many challenges you will and Greece is facing, and children, migrant children are especially facing in your country. I have two questions in the chat, and sorry, there is not much time left for question and answer, but I will raise those two questions, hoping that the speakers are still here. First of all, to Stephanie, a question from Sarah. If I summarize in a way, is there a difference in the feeling of the child, whether he has or not been hurt, whether the outcome of the procedure is or not positive for him? I try to summarize the question. Stephanie, if you are still with us, I hope that you had the chance to read the question, and have you any thoughts about that?
Yeah, I've seen the question. It is not part of my research because the young people that I involve in my research are those that are still in the Netherlands and that have received a status permit in the Netherlands. And I know that Marijke in her research has the intention of also speaking to young people who are illegal, so to say, or had a rejection on their asylum application. So later on in the coming years, she might be able to say more about this. But one observation here is that I think there might be a chance, of course, that their views will be colored by the fact that they have received a positive outcome on their application. But on the other hand, there's a lot of research that also shows that if you treat people in a respectful way and that you give them also the opportunity to have their say and to give their views, they also feel in the end that they have been treated in a fair way, irrespective of the outcome of the procedure. And I think that this really relates also to how to treat children, to treat them with dignity and with respect for the rights, but also them as a person in the procedure really helps them in the way they have perceived the procedure, and that they also feel that it has been a fair procedure. So that is one of the things that could really help here as well, I think. But yeah, more research needs to be conducted as well.
Thank you, Stephanie, and indeed we hope that other research will be made on the topic, and we need to get more information on that. And finally, there is a question to Mauricio from Sofia, who works in a country where there is no guardianship system in place. Unaccompanied minors are represented by the director of the institution where they are placed. From your experience, what problem do you see in this model, and what are the main elements supporting the added value of a guardian system like yours? Maybe Caterina can also add some insight in that, but Mauricio, have you any suggestion about this question?
As long as I know, in Italy too, when there is not a volunteer guardian, the director of the shelter or the social worker, there is anyway for any minors a institutional guardian. The main difference between having a volunteer guardian and the institutional one is very huge. As I said, if the minor has his own volunteer guardian, that makes the difference, because the institutional one has many pupils, many boys, many children to look at. It's not the same thing. And adding to this, as I said, volunteer guardian is not a professional, it's not any. It's a free figure, while the director of the shelter has to manage with the authorities, to manage with many organizations. So it's less free than a volunteer one.
Yeah,
it's unpaid.
the importance of the independence of the guardian. Katerina, do you have anything to add on this?
Yes, thank you, Benoit, and thank you, Maurizio, because it's exactly that. The main issue is that they have lots of boys and girls assigned to them when they are directors of the structures. But that still happens. The civil society in Italy is very engaged and very determined in stopping this to happen, to ensure that all minors have one-to-one, the ratio 1-to-1, one volunteer guardian, one minor. And yes, the main problem, as well as Maurizio said, is that the independence of the actors, because they are highly dependent from the state and from the authorities, and of course they don't have the necessary time. And many times we think that they are professionals, they are the directors of the structure, so they will be more specialized, and they will have more resources to treat these minors and to ensure their best interests. But many times it's not like that, because they don't have specific information and specific training on that, as our voluntary guardians do. So it's a work in progress, but we are happy of what we have come so far. Thank you.
Thank you. And indeed, if I may add just a little piece on this, I know also that in the countries where the director of a social worker of a reception center is involved in guardianship, this means that as soon as the child leaves the accommodation place, this person has no more duty. So the child loses its protection of the guardian. And in the case of Italy and in other countries, like in the Netherlands, in Belgium, the guardian stays whatever happens. If there is a change of a place, if the child leaves the place, goes in a foster family, or runs away, and so on. And so making a link between the reception center and the guardianship, the person who has to protect all children's rights, make it much more difficult for a child. And so that's also an important piece for me. And also, as you mentioned, mixing different roles in one person is a risk of putting more emphasis on some aspects of the mission instead of others. And we have a comment in the chat from Carolina and saying, Katerina, very true, from a reception center coordinator in Austria. So she fully agree what you said. In the other chat, I saw that Marieke was asking all participants also to share their experience, if there is experience in a child-friendly approach for adolescents in migration. So don't hesitate to share your views with Marieke directly if there is any specificity. I have the feeling myself that the vast majority of children in migration are coming from, are belonging to an age between 14 and 18, maybe 15 and 18. So most of them are adolescents, and they have specific needs as adolescents in training, preparing their future, and trying to also enjoy life while there is no so many possibilities. I don't know if someone has anything to add on this specific issue. Stephanie.
Can I add something? Yeah.
Yeah.
I think it's very important issue to address, because, for example, in juvenile justice, we have a lot of emphasis now on adolescents and on the, for example, the brain development of young people, saying that at 18 you're not an adult and maybe you should have special measures after 18 as well. And I think also for young people who arrive in a new country, the same counts, of course, that they have a specific development. and maybe also because of their education or lack of education and the cultural background that they're coming from, that we should not see them too soon as being adult, because I think a lot of 16 and 17-year-olds who arrive here are seen as just another migrant and seen as maybe capable of defending their case and being able to explain themselves and knowing about their future. As when we look at our own children of that age, we would not expect that. So I think it's very important to address this issue, and also after 18 to continue support also for these young people who arrive here. About housing, for example, income, education, there needs to be more attention to that as well.
Thank you, Stephanie, for those last words in this discussion. I see that someone has raised its hand in the participant list. Gert Hadang, are you asking for the floor? If yes, I can give you the chance to speak now. Is it? So where is Gert Hadang? Did you ask for the floor?
No, I did not.
Okay, okay. So I saw your hand in the chat, so it was just a mistake. So it's a pleasure to have you among the participants, and I hope that you and the other enjoy this webinar, this conference. I will just try to give the last words and a quick conclusion of this seminar. If I had to recall one word of this seminar, I would use the word journey, because it's a journey for the children who travel sometimes a long way, and very often a very difficult, dangerous journey for the children. But it's also a journey through the procedure and all the administrative burden. And as Stephanie was just saying, this is certainly not something that we would expect from the national children. So we have heard so many examples on the standard setting, on research, many tools. Many try to implement all those principles and tools and legal framework in the field, but we still see the difficulty to combine, on the one hand, the obligation to lead a child through this journey, administrative journey of the procedure, and to combine it with the fact that we are talking about children, and children first and foremost. So it's difficult to disregard all this legal background, although we as children's rights worker, activist, and also the whole, I would say, legal and administrative community, we need to combine two different issues which are very difficult to combine. Among the difficulties, and we have mentioned so many of them, we have mentioned age assessment, turning 18. Stephanie just recalled a minute ago the importance of looking ahead of the age of majority, because those children don't stop being in need of support and protection when they turn 18, and from one day to another they become a child that needs protection, to an adult that is treated as an adult, but it's still the same person. And so when we think that for a child leaving its country, going through all this procedure is as such a huge challenge, and keeping in mind what one of those children in Greece said, that leaving my country would bring me peace. That was his hope, but it's not the case. So we, as adults and professionals, we really have to continue investing in trying to make a better future for those children. And the states and the authorities have still a long way to go to deliver a real and effective child-friendly environment and procedure for those children. we wish that all those children would not have to go through this lengthy and complicated procedure, and that they would just be allowed to live their life as young person, as a child, enjoying life. But we know that until this utopic goal would be reached, we still have to do a lot of work. So with these words, and I see that there is still, it's not a question, so just a comment. So thank you, Wim Bonny, for your kind words, thanking the audience and the interveners. So it's my turn to thank all the participants to attend this meeting. I hope that you found it useful, and that you have some concrete ideas to bring back and then try to use them in your daily work. I would like to thank and warmly thank all the speakers who took the time and prepared an intervention to share their views, expertise, and knowledge. Of course, I would like to thank all the participants and the partners of the Child Friendly Justice in Action project, because they have done a great job in each country, and we see when we compare the situation in all countries, we see that there is a need to look at what's happening in other countries to try to improve the situation in our own countries. And finally, I would like to thank all the DCI-Belgium staff and colleagues who have done a great job in putting this together, in organizing this agenda, in of course in running this project and coordinating it with all the partners. And we look ahead working with all you and being in touch with you. I just remind you that as Laurent said earlier, we have set up this Child Friendly Justice European network, which aims at gathering and collecting all this experience and putting it together to look at the ways to improve all dimensions of child friendly justice with the whole European community. So there is a place and a website where you can find some information, and don't hesitate to be in touch with us if you want to take part, to bring your expertise, to contribute to this network. It's still work in progress, but I believe that it will also take its part to the whole building of the Child Friendly European, Child Friendly Europe as a whole, which shows more solidarity towards other countries, but more solidarity towards children in the migration. So with these words, I will close the webinar now, and thanking everyone for its patience, and because we are a bit ahead of our time. Thank you very much, and have a good evening. Hope to see you to other events. And just one event, there is an event at national level in Greece. So if you are interested in knowing more about the situation in Greece, don't hesitate to get information about that. That would be also great. I think that this is my final word. I don't know if there is one of the organizer, Laurent or Vanessa, do you have anything to add to that?
Thank you, Benoit, very much for moderating this these discussions and this seminar. It was really interesting. I just wanted to say and tell to everyone, as I just wrote in the chat box, that if you are interested in receiving one of the tools that we presented, so the toolkit for professionals or the European report, do not hesitate to contact us, and we can find a way to send it to you. And it will be available in different languages, as you can see also in the chat box. Thank you.
Laurent, is there an evaluation form at one point?
And we will send an evaluation form as well to the participants.
Okay, so we count on you to fill it in and to send it back as soon as possible. Thank you, good evening, and see you soon.